Thank you for attending the Student Borrower Protection Center and Demos's virtual conference, Delivering on Debt Relief, Canceling Student Debt on Day One and Beyond. Our day will begin with remarks from SBPC Executive Director, Seth Frotman.
Hello, I'm Seth Frotman, the Executive Director of the Student Borrower Protection Center. I'd first like to thank Demos and in particular, Mark Hulsman, for being such great partners in putting together this event. I also want to thank our friends at UC Irvine Law School for their steadfast partnership in our joint student loan law initiative. And I would like to thank all of you for joining us for this remarkable gathering of student loan experts. We're all here today because our country is in the midst of a student debt crisis. For most of you, this is painfully obvious because you live it every day. This looming cloud of student debt casts a growing shadow over our communities and our country. Its effects ripple through households and cities, exposing the deeply entrenched racial, gender, and wealth disparities that sadly have become ubiquitous across American life. And now, as the nation grapples with another crisis before millions of families have recovered from the last one, student debt threatens to add kerosene to the fire of the ongoing economic fallout from the pandemic. Yet armed with the benefit of hindsight and bolstered by the possibilities afforded by a new administration, we recognize that we can and we must act. In 40 days, President-elect Biden will become President Biden, and he will take office already equipped with the tools needed to immediately take action to end the student debt crisis. But to understand why this action is so necessary, we must first understand why these tools were created. As the country replaced access to higher education with availability of debt, Congress passed a series of laws intended to serve as a critical safeguard against runaway student loan balances. Across the ideological spectrum, policymakers agreed that when we collectively shifted the risk of higher education onto the backs of tens of millions of families, there must be strong safety valves to serve as a counterweight. As a primary safeguard, Congress empowered the executive branch with the authority to implement broad-based debt cancellation at the discretion of the Secretary of Education. It also established specific targeted relief designed to eliminate the burden of student loan debt for a diverse range of borrowers facing specific distress. Cumulatively, Congress intended for tens of millions of borrowers to receive relief when the system failed. Lawmakers promised relief for borrowers defrauded by predatory schools. They guaranteed a clean slate for those whose financial hardship had spanned decades, and for those who pass up private sector wages to serve our country or our local communities. They told borrowers that they would not have to fear forces totally out of their control, like an unexpected school closure or the onset of a permanent disability. Unfortunately, these safety valves have failed. Millions of borrowers have been denied access to the very programs and protections Congress intended to serve as a critical backstop against the most significant risks of our debt-fueled higher education system. We see this failure in the rejection of 98% of public service workers seeking the debt relief they were promised. We see this failure in the denial of loan discharges for borrowers with total and permanent disabilities and the subsequent seizure of their disability benefits. The safeguards intended to protect against the worst outcomes are instead perpetuating them. Years of indifference and apathy by policymakers and public officials have allowed the harms of student debt to fester. There has been an unconscionable reticence to provide relief by the very policymakers who sit atop the system they helped break. We can do better. Without a single new act of Congress, President Biden has the power to execute these laws as they were intended and to pry open the safety valves designed to protect borrowers. It's been truly inspiring to see the growing coalition of tireless advocates who have spent years pushing broad-based cancellation from the outer limits of possibility onto the Biden-Harris agenda. However, we must recognize that cancellation at the levels proposed is necessary, but not sufficient. We must also ensure that for the first time, the safety valves established by law serve their intended function. Proposals to eliminate $10,000 in student debt are a critical first step to advance equity and restore justice. But the work cannot and must not end there. We cannot leave behind the public school teacher who took on $60,000 in debt to teach in her hometown, but has been denied promised loan forgiveness. We cannot forget the veteran who was ripped off by a predatory for-profit school and is now stuck with 6 figures in student debt. These approaches to debt relief are not mutually exclusive. Rather, they are inextricably tied together, and all are necessary to rectify the harm imposed upon millions of families. The ideas and policies we talk about today represent the path forward to create a system that protects the most vulnerable among us from the crushing weight of student debt, the relief that was promised but so far has been illusory. Critically, today's panelists are not merely advocating for reforms to protect the next generation of students and families. They are demanding justice for the borrowers who never benefited from the supposed safeguards meant to protect against an inherently risky and fundamentally broken system. Fortunately, there has never been more motivation, more determination, or more power behind the movement to end the student debt crisis. And now, speaking of power, it is my pleasure to introduce a person who certainly needs no introduction. So I would rather use this opportunity to set the stage for today's discussion. In 2011, I was lucky enough to work with then Professor Warren as she turned a legendary article about exploding toasters into a living, breathing, and if I may say so, damn effective federal agency. I'll never forget how even though the CFPB was still months away from opening its doors, Professor Warren, Holly Petraeus, and I drove across the Potomac to a military base in Virginia to hear directly from military families about the financial challenges they faced. And their stories helped shape the agency Professor Warren created to protect them. Fast forward, and Professor Warren is now, of course, Senator Warren, but despite those conversations happening nearly a decade ago, I can still vividly recall the significant number of stories we heard that day about student debt, the way student loans were shaping or even destroying lives and families, the confusion and challenges posed by a student loan industry plagued with problems. While it was a wake-up call for many in that room, for Senator Warren, it was simply confirmation of what she already knew to be true, that student debt was on track to be the defining issue of this generation. But like with so many other issues, Senator Warren was light years ahead of everyone else. Senator Warren was ready. And sure enough, as many of you know well, she had a plan for that. During Senator Warren's time at the Bureau, she fearlessly fought on behalf of student loan borrowers. And from the very beginning, she laid the groundwork to ensure the Bureau's continued focus on their problems. She hired tireless champions like Rohit Chopra. And most importantly, she told us to never let what happened to mortgage borrowers happen to student loan borrowers. But her work on student debt, of course, didn't end when she left the Bureau. As Senator, she continued to make ending the student debt crisis a focal point of her work as she fights for real solution and real relief that can be readily achieved through debt cancellation. So without any further ado, Senator Elizabeth Warren.
Hello, Student Borrower Protection Center and DEMOS and everyone who is in the fight to cancel student loan debt. I am so sorry that we can't do this in person, but I'm glad to have a chance to send along this message. You know, I want to start with a very special hello to Seth Frotman and to his entire team of student debt fighters at SBPC. I know that many of you got started working on student loans back with me at CFPB. We stay in the fights. And I want to thank every one of you for being here today. I want to thank all of you for being here today. And thank you for all of the work that you have done and are doing to try to alleviate the burden of student debt for millions of Americans and to advance economic opportunity for the next generation. Thank you. You know, these are truly unprecedented and challenging times. America is facing historic economic and public health crises. Millions of people are suffering from a deadly pandemic that is raging out of control. And too many Americans are struggling to find jobs and to keep a roof over their heads. Student debt comes into this like an anchor, dragging down our struggling economy, preventing a swift recovery, and restricting opportunity and prosperity for millions of Americans. Even before this pandemic, student loan borrowers were struggling, and Black and brown borrowers struggled the most, especially Black women. We currently have a system where Black borrowers have about a 50-50 chance of defaulting on their loans. Think about that. A system where 12 years after graduating, typical Black borrower owes more on their student loans than they borrowed while they were in school. Anyone who looks at that system and doesn't see a 5-alarm financial emergency in need of bold structural policy changes must have their eyes taped shut. Look, if we don't take action, the pandemic and the recession will make it even harder for borrowers who are already barely treading water. The way I see it, we have a responsibility and a moral obligation to act. We owe it to our fellow Americans to address this crisis head on. We need to broadly cancel student loan debt and put those monthly payments back into our economy. Canceling student loan debt as soon as possible would mean substantial and immediate relief for millions of Americans, many of whom have suddenly found themselves laid off, and many of the rest are worried that their jobs may be next. Now, here's the thing. We have a real chance to make this happen. For the first time in history, the American people just elected a president of the United States and a vice president of the United States, both of whom are committed to canceling billions of dollars in student loan debt. I believe that the lesson from the election is clear. Bold policies like student debt cancellation, policies that improve opportunity, are broadly popular all across this country. Joe and Kamala understand that broadly canceling student debt will improve the lives of tens of millions of Americans, that it will give a huge boost to our economy during this pandemic and beyond, and even help close the racial wealth gap. Republicans have blocked debt cancellation at every opportunity, blocked it for public servants, blocked it for defrauded students, and blocked it for disabled veterans. And they have spent their time in office squeezing students harder. But here's the good news. Joe Biden and Kamala Harris can use existing authority already in the law to cancel up to $50,000 in federal student loan debt for all borrowers with federal loans, and make sure that the loan cancellation doesn't result in any additional tax liability for any of those borrowers. And they don't need Mitch McConnell's permission to make it happen. In fact, canceling student debt is the single most effective executive action available to provide massive consumer-driven stimulus to our economy, which is still hurting because of this pandemic. With the stroke of a pen, the Biden-Harris administration can start putting those monthly payments right back into local communities and help build Black and brown wealth at the same time. You all have been in the trenches for this issue for years, and you already know the facts. You know that student debt prevents people from buying homes and starting small businesses, especially young people who just turned out in record numbers to vote for change on election day because they believe down to their toes that government can work for everyone. I'm glad you all, the experts, the academics, and yeah, the lawyers, I'm glad you're all here, gathered today to talk through the nuts and bolts of how we're going to get this done, to get down into the weeds and help us figure out the details, and to share the latest research about why this is so important for our economy and for our country. Your work is critically important, and now is the moment. You help change the narrative around student loan debt. And because of your work, we know that canceling student debt is progressive. It would stimulate the economy, and it will help Black and brown Americans build wealth and build a stronger future for their families. This is a righteous fight. And I'll let you in on one little secret. The naysayers and the critics are getting louder for one reason and one reason only, because we're winning. Senate Democratic leader Chuck Schumer and I believe that President-elect Biden should cancel up to $50,000 worth of student debt, which would completely wipe out the debt for about 75% of borrowers and give tens of millions of Americans an immediate financial boost. And that is what we're fighting for. But we can't do this alone. And that's why I'm here today. I want to say thank you for all that you have done and for all that you're continuing to do. Let's keep fighting together. Let's cancel student loan debt. We are counting on you. People across this country are counting on you. And I just want you to know, I'm with you all the way.
Our first panel of the day, Canceling Student Debt for Students Defrauded by Predatory Schools, will be moderated by Jonathan Glader, professor at UCLA Law and co-founder of the Student Loan Law Initiative. Jonathan, take it away.
Thank you so much. Good afternoon, everyone, and thanks for joining our opening panel on canceling student debt for students defrauded by predatory schools. I'm a law professor here at UCLA, and I teach education law and policy. Our panel consists of a number of experts, and we're going to be focusing on a set of problems related to student loans, of course. In particular, unscrupulous higher education providers that deceive students into going into debt and then, often enough, collapse before the indebted students complete a course of study. These stories implicate multiple sets of regulations that govern when and how a borrower can assert a defense to repayment, BDR for borrower defense to repayment, regulations that govern what happens when a school closes on a student borrower, and regulations that require a school to certify that a borrower is able to benefit from the education provided. As with so many problems created by student debt, these deceptive acts and practices and school closures prompt questions beyond just the treatment of borrowers about how to regulate this sector. And those questions implicate the gainful employment rules, setting standards that schools participating in federal student aid programs under Title IV of the Higher Education Act that they must meet, and maybe other steps that we'll hear about to detect and deter potential misconduct. Our panelists are Eileen Connor, Legal Director at the Project on Predatory Student Lending at Harvard Law School, and a contributor to the report on delivering on debt relief. Robin Smith, who's of counsel at the National Consumer Law Center and also contributor to the report. Tarek Habash is head of investigations for the Student Borrower Protection Center, and Jan Keo is a fellow at the Century Foundation. Barney Eskandari is supervising Deputy Attorney General for the California Attorney General's Office. I'm going to ask each of them to make some opening remarks in the 5 to 7 minute range, and then we'll have a conversation addressing some of the critical questions that their research and in some cases litigation experiences have raised. And I'm going to start with you, Eileen. Can you tell us a little bit about the kind of work that you do and about the findings in the paper that you and Toby Merrill contributed to the Delivering on Debt Relief report?
Sure, and thank you, Jonathan. Thank you to SBPC and to Demos for hosting this event. I think it's so important to be thinking about what can be done to bring this needed relief to borrowers. So I'm the legal director of something called the Project on Predatory Student Lending at Harvard Law School. I co-lead this project with Toby Merrill and a team of excellent other people. And what we do is we try to make it legally and financially impossible for for-profit colleges to rip students off. And so we're trying to use litigation to realign the incentives, either to make institutions internalize the cost by holding them legally responsible for deceptive acts and practices. And we're also trying to use litigation to ensure that those who are responsible for overseeing this federal student loan program are not allowing it to be used and abused by bad actors. So that brings us to borrower defense, which I think is kind of at the fulcrum of both of these things. We represent over a million former students of for-profit colleges in various cases. We have litigated against the Department of Education beginning under President Obama and continuing today, probably continuing into the next administration, just given where our litigation is. So borrower defense is something that is supposed to be a fail-safe for borrowers. When they take out federal student loans, they should not be obligated to repay them when they were fundamentally cheated because they didn't get the education that they were promised. This is something that's a matter of contract. It's in the higher education statute and it's in department regulations, and it has been for decades. We've only been hearing about it a lot in the past 5 to 6 years, partly because of the epic collapse of certain chains of for-profit colleges, and partly because of growing, I think, pressure on people due to student loan debt and the massive expansion of predatory actors within the system, people getting organized around their student debt, and getting really loud around this issue. So since the tail end of the Obama administration, there has been some action. I think one thing that I wanted to highlight about borrower defense is that it really does have its roots also in this concept of the Federal Trade Commission's rule on the preservation of claims and defenses, which is supposed to act to police the marketplace so that a repeat player like a lender is going to make sure that it's not making loans for people to use to purchase goods and services from basically shady sellers. So in this instance, what we're talking about is the Department of Education being the repeat player. It's in charge entirely of what schools get to create loans for their students. And I think this has a special salience for students of for-profit colleges because that is the group of institutions that the FTC holder rule has always reached because they regulate for-profit entities. So the vast majority of people who have filed for borrower defense to date, and there have been over 350,000 people, and that's not even counting people on whose behalf an application has been made by an attorney general, have asked to be relieved from their loans because of school misconduct. So that's what borrower defense is. How has it been working? It really hasn't been working at all. There have been 3 institutions where students have gotten any cancellation. There's been a sort of a long period of non-adjudication followed by a very short time period in which over 90% of pending borrower defense applications have been denied in a really summary fashion. All of this has been subject to a lot of hard-fought litigation by certainly by my team and by others. So I think looking forward, what we need to think about for the next administration is what is the regulatory landscape? What tools are available on day one? What should the bases be for granting borrower defense? I think the thing is that in this larger conversation around debt cancellation and student debt, the thing that people seem to always agree on, no matter their position on that larger question, is that certainly people who have been ripped off should not be held to their loan obligations. They should get relief. The thing I think it's so important for people to know is that that has not happened. It has been clear as day that these schools have ripped people off, and it has been for a long time. It's been acknowledged by the department. For example, if you think of Corinthian, most people probably assume people with Corinthian don't have any debt anymore. That's just not true. The Department of Education under Obama identified over 300,000 people who should have their loans canceled under borrower defense. Less than 10% of those people today have actually gotten cancellation, and half of those who have gotten it still have remaining loans to repay because they've been subjected to this partial relief formula. So I think it's really important to understand how much this tool has really not come into being because of, I think, partly sort of a hostility of the current administration towards the whole notion of debt cancellation, but also because it hasn't been conceived of in the way that I think that it really needs to be in the spirit of the FTC holder rule, which is a means of making sure not only that schools aren't ripping people off and that we aren't asking people to repay loans where they really are legally not obligated to, but it's meant to force the Department of Education as a regulator to be accountable, to say, we're the one who decides upfront which schools can create this kind of student loan debt. And when we mess up, even if we couldn't have known at the time, because a lot of our regulatory ability, it's backward looking. But once it becomes apparent, borrower defense is there and it has to be used to take the risk of failure where there has been failure off the backs of these individuals who just are really not in a position to bear it, and onto the Department of Education itself. Yes, we should try and recoup money from institutions when we can, and I know we're going to talk about that today. That's something that people on this panel have thought a lot about. But the number one thing is, it's not okay for the Department of Education to act as though it has no role to play, and to continue collecting from people in the face of this really widespread and established school misconduct. I think I turned it back to you.
Thank you, Eileen. We are gonna, I suspect other panelists will be picking up several of the themes that you've introduced. Thank you. Robin, moving to you, you also contributed a paper to the report. Can you tell us a little bit about the kind of work you're doing, and also about the argument of the paper?
Yes, thank you, Jonathan. I'm a senior attorney at a poverty law organization in Los Angeles, where I provide free legal services to low-income student loan borrowers. And I also work as of counsel at the National Consumer Law Center, where I work on these issues at a policy level. And I just want to start out by sharing a story that is emblematic of the many, many student loan borrowers I have assisted over the past 20 years. I have a Latina client who was in the 6th grade when she was removed from her home and placed in the foster care system. For the next 7 years, she was moved between foster homes so frequently that she never completed another grade level. In 1985, she was homeless and 18 and recruited off the street to attend a Delphi Business College. 2 weeks later, after she had taken out student loans to attend the college, the school closed. Over the next 7 years, she struggled with mental health. 2 more for-profit schools recruited her off the street. Because she had not earned a high school diploma, she was eligible for federal financial aid unless each school certified her ability to benefit from her education. Federal law at the time and currently provides that non-high school graduates are not eligible for federal financial aid unless the school certifies that they actually have the basic skills, math, reading, writing, to succeed in their education. These schools did not do that. They did not follow federal law. Despite that, they took out student loans in her name, and she dropped out of both schools shortly after attending because she could not read or write. Both the department and the California Attorney General's office determined that both of these schools engaged in widespread fraud, but my client had never been told that she was eligible for any type of debt relief, even though she's eligible for false certification discharges and closed school discharges. She has suffered from decades of involuntary debt collection and still has a debt balance. She's currently still struggling with homelessness and is luckily in transitional housing at this time. This is not a single case. I have seen this across the country in my role as NCLC and at my office here over and over and over. I want to mention that this is a civil rights issue. Sudden for-profit school closures and false certification fraud disproportionately harm Black and Latinx people. These are students who start out economically disadvantaged by the historical structural racism that is embedded in our economic system. They do what our society tells them to do, and they go to college to improve their economic well-being. They trust that because our federal government has said it's okay for these schools to get student loans, that these must be good schools. They study and they work hard to succeed, and then disaster hits. The schools close, the schools illegally get them debts even though they haven't graduated from high school. And another type of debt that is clearly a civil rights issue is students who have the legal status of having criminal records often cannot obtain jobs in certain industries. Schools are not supposed to enroll these students either if they know that their criminal records will prevent them from getting jobs. Yet most of these students also get federal debts that they cannot discharge, even though the Department of Education has the authority to discharge those debts. And these students end up in a worse financial position than before they enrolled in college. This isn't just a financial setback. This is a lifetime setback that to these students, their families, and their communities. Based on I did a report about closed school discharges, so I'm going to focus on that. Based on the data available from recent school closures, we know that probably a majority of people who are eligible for false certification discharges over the past 35 years have not gotten those discharges. This is despite the fact that the department has both the statutory and regulatory authority to grant automatic discharges, meaning it can grant discharges without requiring applications from student loan borrowers. And in fact, it has in its possession, or in the possession of the loan holders, the data it needs to actually identify these borrowers and grant them closed school discharges. However, it has not done so, and it has not done so for over 30 years. There's no reason to collect debts from these people. They can't afford the debt, first of all. Second of all, they are not the ones who failed here. It is the Department of Education and the schools that failed. So the question is, why are we doing this? Why are we continuing to collect debt against these people? And I think this gets to what Eileen mentioned, is we have to incentivize the department to internalize these costs. We have to incentivize it to do the right thing to prevent these kinds of failures in the first place. And what I posit is we need to, looking forward, instead of spreading the cost of this over time, meaning right now when a school closes, that isn't a hit to the budget because the department can keep collecting forever until those students actually apply for a discharge, right? So the public doesn't see a big hit on the budget. If there was a big hit, so if the department was forced to take an immediate loss for all of those students that were affected by the closure right away, there would be an outcry from the public, and perhaps the department would be better incentivized in the future to avoid that. And I'm positing that all of those students should immediately get discharges, regardless of whether they enroll in a teach out or enroll in transfer credits. Let's remember here that the purpose of the Higher Education Act is to support students and ensure that they can get a quality higher education regardless of whether they can afford it. That's not happening. And so we just need to incentivize the department to do a much better job. And I will end with that. Thanks.
Thank you, Robin. This actually leads nicely to Yan, some of your work, because you've looked at school closures and in particular about some of the warning signs that precede closures. And I wonder if you could briefly describe some of your research and share your findings and especially your recommendations for a more proactive, forward-looking, right, recognition before the problem, how to better police schools that are at risk of collapse and leaving borrowers in the predicament that we've heard about.
Yeah, thanks, Jonathan. And I'm so glad and thankful to Student Borrower Protection Center for putting this together. I don't know about you all, but I've been trying to figure out how to fix my face because I'm so thrilled to be on a panel with these wonderful people who have taught me so much about advocating for students around student loan debt. But the things they're saying are so horrible. So I'm kind of bouncing back and forth between joy that this is coming together and continued frustration and outrage that the things are happening out in the world. So I want to start by kind of positing this question, why do schools close? And I think the answer is really gradually and then suddenly. And part of the problem, if the theme is kind of how do we get the department to internalize some of the costs associated with their bad regulation and enforcement of student loan debt, is that when schools close, the department tries to step in during the suddenly point when everything is already kind of collapsing. And almost always prior to that sudden closure, there's a long lead up. There's that gradual process during which time state attorneys general are filing lawsuits, students are filing complaints through a million different avenues because they're not sure if they should be complaining to their attorney general or their state authorizer or their accrediting agency or through a borrower defense. Student simply doesn't know. And unfortunately, in most of these complaint channels, they never hear back and nothing good happens. So why bother? And that's a problem as well. I think the really key aspect of protecting students better from sudden closures is to start paying attention earlier. And I think there's a day one piece of this, and then there's a beyond piece of this. And I'm going to start with the beyond piece, which I think is really establishing a virtuous cycle that has three components, and I'm going to call them the 3 C's. So right now we're going to start with cancel the debt. That's kind of obvious, and especially in the forms that Eileen and Robin have spoken about, that's not day one, that's like day -100. A lot of these debts, the Corinthian debts, should have been canceled 4 years ago. All of the legal requirements have been met and exceeded. And the students have been, really just waiting. So 1, cancel the debt. 2, cut off bad actors. 3, claw back wealth. And so it needs to kind of be all 3 of those steps. Right now, because the enforcement to cut off the bad actors isn't happening, there also isn't any clawback of wealth. And so the only place to start this cycle is by canceling the debt. And then we can start to feed into this cycle, because if you look at the basis for borrower defense relief or for false certification relief, it's that the school did something unlawful. And guess what? Under the Higher Education Act, when the school did something unlawful, they're not really eligible to continue to receive any taxpayer money anymore. That's not happening, but that's the enforcement piece that I'm talking about when I say cancel the debt. When I say cut them off. Enforce the aspect of higher education law that says, hey, there's all this taxpayer money. It's not just for us to hand out. It is part of a contract with schools that they have to provide these services to students in order to be eligible for this taxpayer benefit program. And in both closed school settings and borrower defense settings, the idea is if the school isn't delivering the goods, why should they get paid? I think part of why these things aren't happening very well is because the department also isn't clawing back money, which I just want to speak to for a second, because, I think that an initial step is to internalize for the department the costs of its oversight failures. But ultimately, we do want to shift those internalized costs from taxpayers, which will be initially funding the relief, to the bad actors, and particularly those executives at the top of the organizational structure of bad acting schools, so that they're eating some of the costs themselves, especially when we know that they are profiting enormously from ripping off schools to begin with. When I say claw back, I want to stop there because that's also a lot of the day one actions that the department is currently authorized to do and just isn't doing. 3 ways to start clawing it back. 1, start using personal liability enforcement so that a school can't just file for bankruptcy and have the executives run off with the stolen goods. 2, there is authority for the department to require schools that are risky to buy an insurance policy on behalf of students and taxpayers. Currently, they're doing a horrible job of making sure that schools have to buy those insurance policies and to buy them at appropriate levels. And I'll say 3 is a third piece. Many schools that are in that gradual phase of heading to closure are already in a status where they're basically on probation with the department, which means the department should be looking more closely at what risks they're doing and stepping up the requirements for these schools to make sure that they're either in a process of winding down and safely teaching out students or closing sooner rather than later. It's going to result in less harm to students.
Thank you, Yan. Turning to Tarek, one of the themes in the report and also in Senator Warren's remarks at the outset were the disproportionate effects of predatory schools' conduct deception, closure on student borrowers who are people of color. And I wonder if you could, again, describe your role at the Student Borrower Protection Center, and also tell us a little bit about some of the research you've been involved in that's helped reveal those disparities.
Yeah, absolutely. Thanks so much, Jonathan. And just for those who don't know me, my name is Tarek Habash. I'm the head of investigations at the Student Borrower Protection Center. And so what that means is I spend a lot of my time just really digging into the various failures of the government, for-profit schools, of the companies that prop up for-profit schools and allow them to continue to exist and prey on students, and predominantly and disproportionately students and borrowers of color. And I think over the last few years, some of the most evident things that we have realized has been this disproportionate effect of student debt and the effect of for-profit schools on students and borrowers of color. I think Senator Warren, like you said, really hit this home that this is a racial justice issue. And I think this issue is compounded by the predatory practices of these schools. I think Robin's story was extremely salient here, in how just one of her clients was affected by a series of schools and being preyed upon turn after turn, offering extremely low quality or no quality education, and putting this individual in massive amounts of debt decades later, still not having been relieved of this debt. And I think Eileen also kind of hit on this. Like, this is very much something that everyone across the spectrum, whatever your thoughts are about the student debt crisis and providing broad-based cancellation and relief for those borrowers, this is the issue that I think is the lowest bar, that everyone agrees that no matter what your perspective is on canceling $10,000 or $50,000 or all of it, like, we should not be collecting the debts of borrowers who have been ripped off by predatory schools. And unfortunately, what we've seen for the last administration, and even before that for the last decade plus, has been this unwillingness to remedy these borrowers who never should have been driven into this debt. And it seems so obvious and like such like an easy thing for us to say, okay, well, we should stop doing this. But it has taken us this long, and it's taken us multiple administrations seeing failure after failure. We had a Senate investigation almost a decade ago looking into the widespread abuses and failures of predatory for-profit schools that investigated almost 24 corporations and issued a 1,000-page report that was scathing. And yet we continue to collect on the debts of students who were enrolled at these schools, who were preyed upon by deceptive practices, who were lied to through the enrollment process, who are given absolutely no quality education, whose loans have by and large defaulted because they don't have the means or the ability to be able to repay these debts, and they were lied to. These companies or these schools are hiring companies to drive these borrowers into forbearance so that they can continue to collect on them, or so that they can continue to collect future student loans because they're not hitting certain thresholds according to like the statutory requirements. And I think Betsy DeVos certainly made this worse, but this was an issue even before that. And I think we're at an inflection point today because we have elected a president and a vice president who, for the first time in my lifetime, are going to prioritize student debt, and who are going to talk about it not just as a higher education issue, but as an equity issue, as an economic issue, as a racial justice issue, and as a generational issue. For the last year, we've heard President-elect Joe Biden go out on the campaign trail and say, enough is enough. It's time that we actually fix this broken system, that we make borrower defense work for students who have been ripped off, that we provide relief for millions of Americans who have been failed by a broken system, and that we hold for-profit schools accountable. That is the very least that we can do. It's something that we can do immediately, and it's something that we must do if we want to actually start to see this system of higher education work for Americans. It is the minimum, and I'm really excited that we're all here. I'm so glad that everyone has been contributing to this work for all these years, because we would not be where we are without the advocates, without the borrowers who have been talking about their stories, and without the legal experts who have been pushing this issue for the last, I don't know how many years now. So thank you.
That's a perfect segue to the question I want to put to you, Barney, because you've been in the trenches in pursuit of bad actors in this area. You've been litigating extensively, and I would ask you to describe some of your work at the California AG's office briefly, and maybe also give a sense of why we see these predatory schools targeting particularly people of color.
Thank you so much, Jonathan. Really happy to be here and humbled to be on this panel with wonderful, wonderful people. So I'm Barney Eskandari. I'm a supervising deputy attorney general at the California Department of Justice. I've been here nearly 10 years. I started just after now Vice President-elect Kamala Harris was first elected California Attorney General. Predatory schools and student debt issues have been a major focus of the office since I've been here, and I've been heavily involved with that work. And so I'll just briefly run through some of the highlights. I was part of the team that prosecuted Corinthian colleges, resulting in the $1.1 billion judgment that ultimately led to Department of Education findings that should have resulted in mass borrower defense relief, but was cut short with this change in administrations. Our office has a pending action against Ashford University, another massive for-profit school. We've sued Navient for student loan servicing misconduct. That action is pending. We've gone after a number of private student loan lenders and holders of those loans. Our state law tool chest is somewhat limited, and I will touch on that briefly. But as far as private loans go, we can go after the holders of those loans, and we've been pretty successful in getting near complete discharge of hundreds of millions of dollars of private student loan debt. We've even brought our criminal tools to bear. We recently brought criminal charges against a group of individuals who were allegedly running a debt relief scam that involved hacking in or unauthorized access to Department of Education computers, servers, in order to change borrowers' data. Ed's Office of Inspector General actually cooperated with that and was instrumental in that investigation. But our tool chest is limited. So federal student loans, only the federal government can discharge those loans. And so when the federal government falls down on the job, there's little recourse, at least, that state enforcers can do. And so one of those limited avenues is to sue the Department of Education. And so over the last 4 years, we have repeatedly sued the Department of Education, and maybe can touch on that a little bit later in the panel, but the APA is a powerful tool and states have standing under it, and we have been involved in, I think, 6 lawsuits against the federal government. So to your question about predatory for-profit institutions preying on people of color, it's a consistent theme in our investigations and prosecutions that predatory for-profit schools actually intentionally target, literally as part of their business models, the most vulnerable members of society. That includes historically underrepresented, those who've been underrepresented and blocked from higher education. And that group overwhelmingly includes people of color. And there are structural and historical and economic reasons for that all been touched on. The others fall into this category too. They're not the overwhelming majority like people of color, but single parents, immigrants, service members, those living at or below the poverty level. They're also aggressively sought out by for-profit schools. In our Corinthian investigation, we got their internal documents, and one of them described, their target demographic in really heartbreaking terms: isolated, impatient, those with low self-esteem, those with few people who care about them. These schools are looking for people, prospective students, who don't know how bad the schools are and who are without people who can assist them to know how bad the schools are. And so vulnerable populations, especially people of color that have historically been shut out of higher education, are the primary pool for predatory schools to prey on. It's really quite heartbreaking. So those are my intro comments, and I'm really looking forward to the panel discussion.
Thank you so much. That's actually a great segue to the first question I want to put to the group, and whoever would like to respond first should please feel free to do so. And we've heard a couple of times now about the criticism of the Federal Department of Education for inaction in this area, even given the tools that we now understand from our experts are available to the department. And so they failed to help borrowers who in many cases are entitled to protection because they were deceived, because the school closed. So the question I put to you all now is, can you describe a little more about what the department in particular has chosen not to do, has failed to do, and what can and should it do in these areas going forward? And this is kind of thinking, and please feel free, don't feel obligated to break your responses into, you know, the day one, the first 100 days, what calls for new rules, what do we want to see the department doing going forward?
So I will quickly jump in here, and I think others will have, I think, possibly more insightful things to say. But as far as I can tell, for the last 4 years, the department has failed to do anything except seek ways to thwart relief to defrauded students and repeal Obama-era regulations that protected students. I mean, I think it's just that stark. And so here are 3 things the department can immediately do, and I'm sure there are more. This is a theme that's come up repeatedly: process the backlog of hundreds of thousands of borrower defense claims. These claims are subject to the 95 rule, the 2016 rule, the horrendous 2019 rule that the current administration promulgated. Almost no loans are going to be subject to that rule because it only applies to loans first dispersed after July 1st, 2020. On top of that, is, I believe Eileen mentioned, there's the master promissory note, the holder rule applies. So there's nothing stopping the department from processing this backlog immediately on day one. Closed school discharges come up. There's nothing stopping the department from automatically granting closed school discharge. This administration has been hostile to it. I really hope the next administration is not. And finally, make loan servicing work. A properly functioning loan servicing system can reduce the pain that borrowers are facing. This means at a minimum ensuring that people are properly put in income-driven repayment programs, which for some borrowers are going to yield $0 monthly payments, and that public service loan forgiveness and the temporary expanded program are working as well.
Others want to jump? I see you. I'm muted. Eileen, please.
Yeah, thanks. So I think something that needs to happen, and what the department has failed to do, is to use the broad authority that it has to administer borrower defense, and that includes doing it without application, doing it at the request of an attorney general, doing it on the basis of common established facts and evidence. And I think that for example, I think that there's just been a real misperception about what the true threat is here. So the true threat to the federal student loan program is not that a borrower who went to HEALD in California may get borrower defense relief, but did not actually rely on a published placement rate that was misstated. But that was the concern. The concern was, we can't possibly let anybody get loan cancellation until it is proven beyond a certain threshold that they themselves are worthy of it. Instead of asking, what right does the Department of Education have to collect this loan in the face of all of this evidence? What sense does it make to require people who the department's own analysis show are living at or below poverty after having gone to these schools, making less than they did before, making less than somebody with just a high school education? What kind of a windfall are we protecting against? The real threat, I think, to the federal student loan program is a lack of public confidence that the department is actually a good steward of this program, that people are going to be able to, as Robin said, like listen to the message that we give people, that higher education is a really safe bet and a really worthwhile endeavor, because they're going to see, for example, that the Department of Education will let companies pocket the money, declare bankruptcy and walk away, while students, they will chase them until they die and take their earned income tax credits, take their wages if they're even lucky enough to be able to work in service of this debt. So I think taking the most legally conservative position has been the default of the Department of Education. And I think that's something that just really needs to change going forward. And I think specifically what that looks like, discussing the options in the paper, but they need to, on day one, at a minimum, they need to reopen every single borrower defense application. They need to retract the partial relief policy of this administration. They need to look at any grounds for granting every single pending borrower defense application. And I can tell you that the conduct of this administration under DeVos in any normal circumstances would make the debt uncollectible because of the illegality with which this program has been administered. And I think there's a clear opening to do that based just on the misconduct of DeVos alone. I mean, we all know that the Trump administration really loses every single time it goes to court, and it doesn't really care about following the law. But there's only one head of an agency under President Trump who has been held in contempt of court, and that's Betsy DeVos. So like, the door is open. It needs to be walked through. You shouldn't look back. You should make borrower defense more accessible and more broadly granted going forward. I think that that's the imperative here.
And I just want to piggyback on Eileen. I think we need to change how we have to flip on its head how we view this whole system when a school collapses. Instead of putting the burden on borrowers to prove that they didn't somehow benefit from their education, we need to presume that they didn't and absolutely wipe out the debt and give them a fresh start. They are not the people who did anything wrong here. And to pursue them as if they are somehow at fault, which is what we do, that's the narrative we have, is that if they're not paying their loans, even though they went to a terrible school, they're at fault. We need to reverse it so that from the minute there's an event that reveals that a school has defrauded thousands of people, whether it's an AG judgment or a findings by the government or a school closure, immediately the government needs to wipe out those debts from day one. Take that hit and either retract that money from the school or pay for it itself. We need to just change the narrative completely in the way that we approach these situations. And I would posit that the department currently has the statutory authority to do it. It can clearly do that for false cert and for closed school discharges. With some minor, I would say, regulatory changes, it also has the authority to do that when there is state law or federal law violations. But again, there may be some regulatory changes that have to happen, but those changes can be made by this administration and should be something that they focus on from day one as well.
I know time is short, but I wanted to add an enforcement point and a policy point in terms of some immediate actions. So we've talked a bit about borrower defense and the examples of ITT and Corinthian, where broad fraud was established and there's a lot of claims and a lot of borrowers who need relief. I have a piece that I never published. It's called DeVry Owes Taxpayers Millions. Why won't DeVos collect? So DeVry University is one of these examples where there's an FTC case joined by a lot of state attorneys general. The school settled for $100 million, claims that they lied to students about the earnings and employment outcomes for years. The Department of Education made findings that the school engaged in misrepresentations. If you put together end to end the debts of the students who took out loans during the period of those findings, that the school engaged in unlawful behaviors, you have about $1 billion of relief. And so this is the school where there are the most borrower defense claims that is still open, and the department needs to start collecting money from DeVry to make sure that they get some money back of what they have sent out to students when they start to provide relief to students who've been defrauded there. That's one aspect. I think as a policy matter looking forward, it's really important to enforce something called the incentive compensation ban, to take away some of the structural incentives that have been leading to frontline misrepresentations to the student by the person who's trying to convince the student to enroll and take out student loans. So the idea of the incentive compensation ban is the salesperson shouldn't be working on commission. Unfortunately, it's only been applied to kind of the lowest level person in the massive coordinated scam. So if you pay an enrollment recruiter a bonus for taking in 1,000 students, that's unlawful. If a for-profit school makes a lot more money because they enrolled another 1,000 students, that's fine. If a nonprofit school decides to contract with a for-profit company to enroll another 1,000 students, that seems to be fine too. And that last piece is not statute, it's not regulation, it is guidance. The Department of Education's IG has said it's guidance that conflicts with the language of statute, and I think that's a place to start with policy on day one. Also a place where litigation might be able to help push that policy along.
And John, if I can just weigh in very briefly, just on the moral imperative here, and I think everyone kind of hit on this, but I think we just have to remember that like people's lives have quite literally been destroyed here. This needs to be something that is immediate. I think Eileen, Robin, Barney, Yan all said this. Like we have led entire generations to believe this dream that there's this promise that like if you go and seek higher education and you get a degree, you are going to be able to pull yourself up by your bootstraps and you are going to be able to provide for your family. And we have allowed scammers for decades to prey on this promise without holding them accountable, without regulating them properly, without ensuring that their accreditation means something. And we've let them systematically prey on millions of Americans. And we blame the borrowers. We've said, you are still responsible for this debt. There's this like mythical social contract that only applies to borrowers, but not to the government for failing to hold schools accountable, not to hold the scammers accountable and make sure that they're actually providing what they're promising students. And I think that has caused, as I can't remember who it was that said this, but there's a responsibility that we have to the borrowers to make them whole. And like, this needs to be done immediately. We can't wait on this. So
Tariq, your comments bring to light again sort of the structural issues that we should be worried about. And so the next thing I want to ask is putting aside for a moment existing authority, right? And this is not to say that we don't require immediate action. I mean, people are suffering right now in concrete and measurable ways. But from a rulemaking perspective, what more would you want to see out of this administration? I'm wondering not just about borrower defense here, but also about restoration of gainful employment, which we haven't really talked about and that I know all of you know a lot about, and perhaps regulations in other areas as well that would go towards assuring more equitable access to education for the populations right now that are being preyed on, as Barney put it, by unscrupulous actors. I mean, what kind of regulations should we be hoping for?
Yeah, and I'll just throw a couple out there quickly. So we've talked about the restoration of gainful employment, but I think there is an opportunity to also expand what can be done here in terms of providing borrowers with actual relief. There's an ability to benefit provision within the false certification rules that Robin has already talked about. And I think there's an opportunity to say, like, for borrowers who are attending schools that are failing that gainful employment metric, you are clearly not, you do not have an ability to benefit. Your school has not actually done the minimum to allow you to be able to repay your debt, let alone to see a benefit from the program beyond that. You aren't really able to support yourself and your family if you can't even meet the minimum ability to repay your own student loans. So I think like tying those together and providing explicit relief for borrowers who attended those schools and programs who failed that metric needs to be near the top of the list. I think separately, I think closing some pretty critical loopholes that allow schools to evade important rules and allow them to continue to bring in pretty significant amounts of federal student loans. Evading the cohort default rate, for example, is something that we need to make sure we hold the schools and the companies that they hire accountable. And then I think separately, just making sure that we strengthen the quality assurance system that we have through accreditors to ensure that they're actually evaluating whether schools are appropriately providing high quality educations to students and rooting out schools from the student loan system that are putting students in massive amounts of debt, but not really providing anything substantive.
Eric, real quick, and this is my fault. Can you, in like 30 seconds, just explain the gainful employment rule?
Sure, sorry. So the gainful employment rule is based in the Higher Education Act, where essentially if you are providing a vocational training program or something related to career advancement, you are subject to the gainful employment rule, which looks at a debt to income ratio and evaluates on a programmatic level, not an institution level, whether the program is actually producing a certain essentially determining whether your graduates, it's only evaluating your graduates, by the way, whether they are able to earn enough money to repay the debt that they took on from the school. And so it looks at the median levels and makes sure that people are able to actually afford the education that they're taking on.
Got it. Thank you. And I know, Yan, you were waiting to jump in, and then Robin.
Okay, so structurally, it needs to be easier for people to sue the Department of Education. One of the reasons why they are so resistant to using some of this authority that they have is because sketchy schools are lawyered up. And if you say, hey, we're going to use this authority that we have to request more money from you or to cut you off, best be sure they will be threatened with litigation. But on the other hand, when they say to students, hey, we're going to withhold some of this money from you, they aren't sued and they aren't threatened with litigation in the same way. And so I think that's one of the things that needs to be structurally changed. There are a few ways to do this, but one is that the schools owe fiduciary duty to use Title IV funds in a way that advances the goals of the Higher Education Act. And, they could deputize private individuals to kind of help enforce that fiduciary duty.
And one thing I wanted to mention was I think what the department can do from day one is to staff up and create a really strong law enforcement section. The department doesn't have one. The way it monitors schools is through program reviews and audits, but it doesn't have a unit that's specifically tasked with identifying the riskiest schools and investigating them. It needs to hire seasoned law enforcement folks, investigators, and attorneys who are in a separate unit so that they're not compromised and they have a very clear position of what they need to be doing. And so I think that also should be a priority from day one to sort of start in on finding the for-profit schools and taking actions against the ones that are currently engaging in fraud.
Eileen, sorry.
Yeah, just going back to talking about regulation, I think that as it relates to borrower defense, what the statute requires is that the department specify in regulation what acts or omissions of a school would create a borrower defense. And so it's not the case that those regulations need to be labeled themselves borrower defense regulations. And I think that there's room in new rulemaking, but also using guidance and directives to designate program integrity regulations that have been discussed here, like the incentive compensation ban, like gainful employment, as themselves giving rise when they're violated to a borrower defense. And I think that that would do a lot to enhance program integrity and to make sure that that we make borrowers whole when they aren't getting what they bargained for.
The other dimension I want to ask about in terms of the Federal Department of Education under the new administration is there's a possibility, Barney, I'm looking at you, that you won't have to sue them anymore to get them to do things that might be favorable to borrowers' interests. So I wonder if you could say a little bit about how the department could work with states instead of finding themselves the defendant in suits filed by states over treatment of student borrowers, both by the servicers and by some of these institutions we've been talking about.
So thank you. I think one of the most productive sort of examples of state Department of Education cooperation is out of Corinthian. And so, findings for us are very expensive and resource intensive. What I mean by that are findings of fraud or misconduct by a school. But findings are the name of the game. That's what leads to judgments, and findings are what lead to borrower defense relief. So in Corinthian, we issued document requests and went document by document through a painstaking process and real sort of gumshoe detective work in order to develop, establish widespread gross misrepresentations of job placement rates. We were then able to share those findings with the Department of Education, who could bring their tools to bear by finding Corinthian, putting Corinthian on heightened cash management. The tool chest that Ed has could then be brought. And then, based on those findings, we can bring enforcement actions and get restitution, injunction, and penalties against the school. But it's all about the findings, and it needs to be a two-way street. So we do a lot of the work and we share it with Ed. Ed also does a lot of the work, and before the last 4 years, they used to share it with us and we could bring our tools to bear. And so I'm hoping that on day one, the sharing and the cooperation opens back up again, because that's a real way to protect borrowers, put these schools out of business, and ensure the system is working.
I have one last question that I want to throw out, and I'm asking it now because I want to give everyone a chance to weigh in on this one. And this one's really about advice to our audience. What can people do to further the goals of administrative debt cancellation in the current political moment? People who are inside government, people who are outside government, researchers, members of the public, advocates. What are steps that you all would like to see people try to take to support some of the policies and practices that we've been talking about?
I can go. I would encourage people who've experienced these practices to call their congresspeople and their senators and share their stories. Congress isn't going to hold the department accountable until it really hears your stories and knows what's going on. And really, you should be flooding their phones, whether they're Republicans or Democrats. They need to hear you. And if they hear from enough of you, that really is what I think is going to push change. So that would be my immediate response to that question.
I think use existing authorities to sue the Department of Education, create counter pressure to the threat of lawsuits from schools.
I think it's really important for the incoming administration and people who are in policymaking roles to center the experiences of borrowers and to make an effort to hear from them. We know that they hear from industry all the time. There's not an organized funded lobby on behalf of students. We try and do what we can with our litigation. But I think it's really important to overcorrect for that and to make sure that at every step, you're reaching out and trying to hear from and understand the experiences that borrowers are having and have had, because I think that that's the only thing that's going to align the policy to the reality that as Tarek said, people's lives have been destroyed, and to do nothing is just to be complicit in that, and we can't do nothing.
Yeah, and I think there's certainly a lot of people who have been working on these issues for years, and borrower stories are some of the most impactful things that can really move the needle for policymakers to understand how serious of an issue this is and how widespread this is. kind of as Eileen said, I think like there's a new administration coming, and I mentioned this at the top, there's an inflection point where we have potentially the most progressive incoming administration on student debt and on higher education. And I think there has just been a decade, if not longer, amount of time of just almost paralysis when it comes to providing relief for borrowers who have really just been failed by the system, but in particular, borrowers who have been preyed upon by predatory schools. And, you know, this is not going to just happen by itself, however easy we think like connecting these dots are. And we need to be pushing from all sides. It can't just be the borrowers and the advocates on the outside. If you're on the inside, if you are working in this administration, you need to be fighting for this every single day, because it's not going to just happen. We all have to make it happen.
Anyone else with additional thoughts on steps people out in the world can do to help push this along? Okay. Then since we have one additional minute, I'm gonna add one to this, which is the political economy question, which Tara, you were just hinting at, right? I mean, so we don't know yet who's going to control the Senate, and obviously that's a factor on the legislative front. But I mean, can we guesstimate what's the likelihood of all of the kinds of measures we've been talking about in the coming really months?
Yeah, just really quickly, I think on the campaign trail, now President-elect Joe Biden made it clear that this was a priority. And as I said from the beginning, this is like the easiest thing for us to get done, because I think there is clearly bipartisan support for this issue. Republicans even voted for the Congressional Review Act to undo the Betsy DeVos rule. So there are even people on the Republican side of the aisle who support providing relief for defrauded borrowers. The time is now. Put your money where your mouth is. Get this done, period.
I also want to add that there are some great advocates in the room who've been paying attention to all these points and are, we're preaching to the choir a little bit. But I encourage those folks to consider working in the Department of Education. Robin said that there needs to be an enforcement team, and I encourage people to, help build something that's stronger than what we've ever seen in the department before.
So we're at time. I want to thank the panelists for bringing, really remarkable perspective to these issues, both the very high level big picture, but also really into the weeds. I want to thank the Student Borrower Protection Center for helping put this together, to Demos for helping put this event on and pushing this conversation forward. And I hope that the points that have been made here, the analyses of the problems, the proposals for action in very concrete ways going forward, will help us move closer to the fundamental goal of the Higher Education Act of greater equity and access to higher ed. For those who want to learn more about these proposals and others made by others on panels later in the day, please take a look at the full report, which is at protectborrowers.org, so that we can take steps toward addressing this student debt crisis. Thank you all.
Just a note, our next panel will start in 5 minutes at 1:25 p.m. Welcome back for our second panel of the day titled Canceling Student Debt for Public Service Workers, Military Families, and Vulnerable Borrowers. This panel will be moderated by Mike Pierce, Policy Director at Student Borrower Protection Center. Mike, take it away.
Hello, everybody. Thank you and welcome back to Delivering on Debt Relief. We are about to get rolling with our second panel of the day. Today, we're going to be focusing on, for this panel, we're going to be focusing on some really interesting papers focused on borrowers that had avenues for debt relief due to having a low income over a long period of time, or working in public service, or serving in the military, or having a disability. And I think that just to kind of open up with a little bit of framing, we're going to hear from a number of our paper authors that have really exciting ideas about how to make these systems work better for all of the people that had been promised for decades debt relief under the Higher Education Act. And I'm really excited to be joined by this incredible group of experts here, and we're going to do our best to try to keep this conversation focused on the practical steps that the new administration can take to be able to deliver on this promise for all of the people that have been in the system for a long time and have really struggled to be able to manage their student debt and shouldn't have had to do so in the first place. So first, we're going to hear from our paper authors, and then we're going to hear from a couple of other experts that we've been lucky enough to have join us here. And we're going to end this conversation, I think, looking forward to what the audience, we're really lucky to be joined with an audience full of scholars and academics and experts and lawyers and student loan borrower advocates and the people that are really in the trenches helping individuals make heads or tails of the system. And so we're going to try to leave you guys with some advice on how you can best be advocates in this really special moment we find ourselves in. I think the group of folks that are on this panel have been doing this work collectively for like a half a century. And it's really exciting to have so many people tune in and care about the guts of how the student loan system works or doesn't work. And so it is really just it's my pleasure and my privilege to be able to have this conversation with you guys today. So welcome, everybody. And to start, I'm going to start with you, Persis. I think your paper was really interesting, focused on the rights that low-income consumers have to make an affordable loan payment and what's gone wrong with that system. Would you mind kicking us off by introducing yourself, talking about your research a little bit, and just giving the perspective of the low-income borrowers that you work on behalf of?
Yeah, absolutely. Thank you, Mike, and to the Student Borrower Protection Center and Demos for putting on this event. Hi, everyone. My name is Persis Yu, and I am the director of the Student Loan Borrower Assistance Project at the National Consumer Law Center. Just a bit about us is we represent low-income student loan borrowers, both through public policy work, but also through some direct representation. And one thing to keep in mind is that over the last several decades, but in particular in the 90s, we saw a huge erosion of the safety net for student loan borrowers. We saw the elimination of the statute of limitations. We saw further restrictions on bankruptcy rights, implementation of the cutely called Debt Collection Improvement Act, which allows for the seizure of tax refunds, earned income tax credits, Social Security benefits, all sorts of lovely things. But the HEA the Higher Education Act, does offer, in theory, at least some important protections, which many of our panelists my co-panelists are speaking about as well. Income-driven repayment is one of the key protections that is meant to help our low-income borrowers. It is both a repayment plan and a cancellation program, kind of all at once. And the theory of this program is to provide borrowers with an affordable path to repayment and ensure that borrowers are not saddled with debt for the rest of their lives, which sounds like a really amazing and lovely goal to have. Except for the fact that it's failing. And so, for a lot of borrowers, the promise of income-driven repayment has just not been fulfilled. We did some research through Freedom of Information Act request and found that as of last year, fewer than 20 borrowers. They actually couldn't even give me the number of borrowers because there's so few that might be identifying in some way. So fewer than 20 borrowers have received cancellation through the income-driven repayment programs. And too often when problems arise, and there are many problems that have led to this, ridiculously low number of borrowers accessing the benefits, and I'm hoping that my co-panelist Shannon will talk about some of those. But too often when these problems arise, the department and the servicers just kind of shrug their shoulders and say, well, our hands are tied by the regulations. This is all that we can do. So what I was hoping to do through this paper is look at what flexibility really does exist through the Higher Education Act. And, looking at the IBR statute and the income contingent repayment statute, I think that the department has unnecessarily tied their own hands in this way, that these statutes are really much more flexible than the department has interpreted them to be, or has at least implemented them to be. And so on the highest level, we can be doing a lot more for borrowers. Some of the really striking takeaways that I took away from this was that we can be canceling loans in a much shorter period of time, that there's actually no minimum number of payments that need to be made under each of these statutes. We can, and frankly, we should be providing benefits to defaulted borrowers. The fact that the department has not implemented, but actually both of these statutes expressly allow defaulted borrowers to access the program, and we have not allowed them to do so. And we can be counting payments that were made prior to a consolidation, which is another thing the department hasn't done. So I dive into more details in what is probably a too long paper. But the highest level takeaway is that I think, we could be canceling all the loans of any borrower who has ever enrolled in an income-driven repayment plan and made as much as a single qualifying payment. And I think, that's the starting place, and maybe that's not where we wind up, but that's the ultimate flexibility of these statutes, and we should be implementing them in a way to provide the relief for the borrowers, especially the borrowers who have been struggling for the most number of years. Thanks, Mike.
Thank you so much, Persis. That was awesome. And I had to say, I really loved your paper. And I really came away from it. I came away from your remarks just being struck by how it's not really much of a safety net when we've made these policy choices to exclude the most vulnerable borrowers. And so it was really great to be able to do a deep dive into the law and to realize that the law is actually much better than maybe a bunch of the lawyers that work on it understood, myself included. So next, I wanted to turn this over to Bethany. Bethany, would you mind introducing yourself briefly? And then talk about your research, and particularly talk about what total and permanent disability discharge is, who it's intended to protect, why it's failed, and then how your vision would suggest that President Biden should take action to repair the damage.
Well, hi, everybody. My name is Bethany Lilly, and I am the Director of Income Policy at the ARC of the United States. We represent people with intellectual and developmental disabilities and their families. And I also co-chair the Financial Security Task Force for a large DC consortium of organizations that represent kind of a cross-disability set of issues. And that is very much how I come to this, from a cross-disability perspective. And that is exactly what the TPD program is supposed to, the folks that the TPD program is supposed to help. It is supposed to help people who have become disabled to such a degree that they have difficulty working and paying back their loans. It's tied directly into another program that I spend an extensive amount of my time with, the Social Security disability system, which is equally as complicated and messy. And I think we could all probably agree needs some of the same types of reforms around kind of automatic processing. But all of that being said, TPD is supposed to help borrowers with disabilities. So if you go to school and you take out loans and then you get into a car accident and end up with a traumatic brain injury or a spinal cord injury, if you went to school and you were diagnosed with MS later on, and over time it has become such, your functional limitations have increased to a degree that you can no longer pay back your loans and can no longer work in the same way, TPD is supposed to step in and help those folks. Unfortunately, the way that the program works right now includes a lot of bureaucratic barriers. And I think I'm going to build a lot on what Persis had to say about the program not really working for people in the way that it should. The number that really struck me as we were pulling all of this together was that there are over 400,000 borrowers on Social Security disability programs right now that have federal student loan debt and aren't going through a discharge process. They haven't gotten those loans discharged. And that's truly shocking to me. If we have 400,000 people that the Department of Education and the Social Security Administration acknowledge have this debt and acknowledge that they are eligible and they have that debt has not been discharged, that's a failure of the system in and of itself. And so we go through a lot of recommendations in the paper, and I would highly encourage folks to take a look at it. But I think probably the biggest recommendation that we have is automating this process as much as we can. By definition, we're talking about folks who are on Social Security disability and have difficulties working. And so those same types of skills that you might need to jump through all the bureaucratic hoops of the current system to fill out paperwork, to make sure the government has your updated income information, those are exactly the kind of barriers that folks with disabilities face because of their disability. And so that's something we really need to take into account. And I think automation would be a really big part of it. And much like Persis said, the way that the Department of Education wrote the regulations in 2012, two Social Security lawyers, and my colleague and I, who wrote the paper with me, were both Social Security lawyers. We kind of looked at the reg and we're just like, but that doesn't make any sense. And so much of our paper is kind of outlining, I don't think the Department of Education quite understood how pieces of the Social Security system work. And so outlining how they could look at other systems and or other pieces of the Social Security system and build off of those, I think will be really important going forward. And we think that the Biden administration has a lot of authority to act on this immediately. I mean, we've seen how COVID rates are impacting people with disabilities. I mean, we have some of the highest death rates, especially the population I represent right now, folks with IDD. And being able to help people who, I mean, there are people who are actually having their Social Security benefits garnished right now because they're in default on their student loans. And that is, despite being eligible, that's the part that just drives me up the wall. But yeah, so that's my short summary of our paper.
Thanks so much, Bethany. And again, it's a really interesting paper. And it's great to have a disability advocate's eyes on what has been treated for a really long time. It's like a higher education policy issue by people that don't work with that community and don't understand the mechanics of these programs. And so we were really excited to be able to feature that writing in this volume. And I hope that, I think it's all of our hope that the next administration listens to the voices of the people that are the closest to the communities that these policies affect. Which is actually, I think, a great segue to talk to you, Mike, now a little bit about your paper. We, I think, have spent a lot of time dissecting the Public Service Loan Forgiveness Program and all of its flaws. It kind of famously has rejected 98% of the people that have applied for it. But you approach the issue from the perspective of military borrowers, of service members and veterans. Would you mind introducing yourself a little bit and then talking about what your research found and your recommendations for action?
Sure. So I'm Mike Saunders. Today I am representing the Student Borrower Protection Center as a military fellow, but I have spent about the last decade advocating on behalf of active duty service members, their families, veterans and survivors in front of Congress and the executive branch. Just to frame the issue for everybody, because a lot of people think that, you know, how much does this student debt issue affect the military connected community? And the answer is quite a bit. So recent research by Veterans Education Success has found that in the 2015-16 school year, 11% of veterans at two-year public institutions had federal student loans, 32% of veterans at four-year public and nonprofit institutions had federal student loan debt, and 42% of veterans at for-profit institutions had federal student loan debt, and that is despite having access to the GI Bill. So when combined with the fact that in 2017, CFPB reported that 200,000 active duty service members owed nearly $3 billion in federal student loan debt, numbers that in all likelihood have only gotten bigger in the intervening years, it is clear that student debt's a big deal for the military connected student community. One of the reasons the number of active duty borrowers is so large was noted by Holly Petraeus during her time as the head of the Office of Service Member Affairs at CFPB. Many of them are coming onto active duty already carrying some of this debt. They may have already attended an institution of higher learning and left before they earned a credential, and it is likely one of the factors that incentivized them in coming onto active duty in the first place. The Student Borrower Protection Center did a Freedom of Information Act request recently, thanks Tarek, Ben, and the team over there, and found that despite there being over 200,000 active duty service members owing student debt, federal student debt, only a fraction of these borrowers, roughly about 17,000, had even submitted an employer certification form indicating an interest in participating in public service loan forgiveness. Military service is the quintessential public service, and yet military borrowers are continually denied access to public service loan forgiveness. Notably, despite their clearly qualifying service, nearly a quarter of those borrowers' ECFs were denied. One of the main reasons for this is quite possibly the nature of military service itself. It can take hours on the phone with your student loan servicer to get enrolled in or to recertify for income-driven repayment. Hours that people who were deployed to war zones, under the sea for 6 months on a submarine, training at the Joint Rotational Training Center at Fort Polk, Louisiana, or the National Training Center at Fort Irwin, California. So they simply don't have that type of time. In fact, in the military, you're taught that it's a 24-hour, 7-day-a-week job. And you're told that you're on Uncle Sam's time. So one potential way identified in the paper to get at this is the HEROES Act in 2003, which provides the Secretary of Education the authority to grant financial and administrative relief to veterans affected by war, military operations, or national emergencies. In particular, the HEROES Act adds emergency powers to the Higher Education Act, which allow the Secretary to execute waivers and modifications of any statutory or regulatory provision applicable to Title IV funds as the Secretary deems necessary in connection with a war or military operation. Notably, the HEROES Act expressly permits the Secretary to authorize broad-scale waivers for classes of borrowers. In fact, this is the authority that Betsy DeVos just used to extend the CARES Act pause on student loan payments and interest accumulation until January 31st of next year. We have been a country at war since September 11, 2001. So the incoming Secretary of Education should use this authority to ensure that all who served on active duty since the creation of the Public Service Loan Forgiveness Program receive credit for their time in service, regardless of whether they satisfy the other requirements of the program. Additionally, the next Secretary should take immediate action to forgive the loans of borrowers who have served on active duty for at least 10 years or have served their communities and country for at least 10 years through a combination of military and civilian service. This could possibly be the leading edge of the executive actions the incoming Biden administration takes to deliver broad-scale debt cancellation using existing legal authorities. The military is used to being the tip of the spear. This time they can do the same and lead the way for their civilian counterparts who are also struggling under student loan debt.
Thanks so much, Mike. That's awesome, and a great overview of a really interesting paper. We're going to come back to that HEROES Act authority, I think, a couple times in our discussion today. It does offer an incredible opportunity for the Secretary to do right by men and women in uniform, something that should have happened a long time ago. But it also offers kind of a broader opportunity to seize this moment we live in the context of the pandemic. And as I think you rightly mentioned, it's been used by the Trump administration to provide immediate debt relief for tens of millions of people. So I do want to make sure we come baft to that. But first, I wanted to ask you, Alyssa, to introduce yourself, talk a little bit about the work that you've been doing. You've been in the trenches at AFT for a long time, trying to help individual teachers, healthcare workers, other workers make heads or tails of the Public Service Loan Forgiveness Program, the Teach Grant Program, Teacher Loan Forgiveness. Can you share a little bit about your experience working with individual borrowers and really just try to give borrowers a voice in this discussion?
Yeah, happy to do. Thank you. My name is Alyssa Picard. I'm the director of the Higher Education Division at AFT here in DC. I worked for our state and local unions before I came to DC as an organizer and as a negotiator. So I come to this without the perspective of an attorney, which is a really strange set of tools to be lacking in dealing with student debt land. When I started in my current job, I kind of inherited a student debt clinic program that was in its nascent stages at AFT. And that program had arisen out of an effort to put together an economics curriculum for working people. The very first iteration of bringing together union members to talk about what they would want to learn about economics and about the aspects of of economics that affect them the most resulted in so much conversation about student loan debt that the rest of the curriculum was never actually created. The student debt clinic work came out of it, and we have been driving that ever since. So the context for us is that almost every one of our 1.7 million members needs some amount of college credentialing in order to hold the jobs that make them our members. And that means that many, many, many of our members have student loan debt. In higher education specifically, the 230,000 members we have who are faculty and staff at colleges and universities in this country, roughly half of those members and about 3/4 of all in the industry are adjunct. They are working in what are essentially gig economy jobs, which I mentioned to say that the predation in this system is not just on students, it is also impacting our members in their role as borrowers and as providers in the higher education system. But what's common across all of our constituencies is that there's overwhelming confusion and obstacles accessing IDR and public service loan forgiveness. The kind of nightmare story that come to us from an adjunct member in Palomar, California, is of somebody who had repeatedly applied and actually met all of the formal criteria to get public service loan forgiveness. He had the right loans. He'd made 120 on-time payments, but he ended up trapped in kind of a bureaucratic nightmare having to do with the forms that he needed to fill out. They were first rejected because he had provided an electronic signature, and and he was told that he had to have a hand signature. When he sent the hand signature, he was told that he didn't have the most current form, and the forms changed again in the time when he was doing the application. So the last thing that he wrote to us about it was, I'm almost certain that they're going to reject and deny this application again, indicating that I must download the very newest form, even though both agents on the phone told me that would not be necessary. He'd spent a lot of time talking to his servicer and to the Department of Education. I fear I will have to email one school and physically go see another school to get the chairs and HR persons to re-sign the form. Unfortunately, in the middle of this, he experienced a partial layoff. So he'd been teaching X number of classes as an adjunct to make the 30 hours a week. And he ended up losing one of those classes. I'm only working at one school now. If they ask for verification of these forms yet again, I'm not working at both schools, and they will deny me PSLF on those grounds, even though I made all 120 payments working full-time between the two jobs for the last 10 years, because there's also a requirement that you be currently still meeting all the requirements for PSLF. I don't know what you can advise me or how you can intercede, but the application should be assessed on the conditions when I applied, which were last fall, teaching 2 classes per school at 16 hours per, totaling 32 hours, which is a completely reasonable way to think about what should happen to you if you're in this system. And what he was saying to us effectively was, how do I appeal a bad decision in this process? And the answer, of course, as many folks on this call know, is that there is no appeals process. I mean, you can apply again, but your application is going to go through the same process it went through the first time. And so this guy, for all intents and purposes, is living in, like, you know, the Terry Gilliam's movie Brazil when it comes to his student loan debt. Like, he's throwing forms of increasing complexity into the maw of a process that doesn't make any sense, and that's continually kicking him out rejections and telling him this is just not going to work for you. So, you know, we've all shared the experience of COVID. Our members are on the front line in that experience in some very dramatic ways. They are the people who are making the benefits of functioning government available to other people at all kinds of levels, right? Teachers and teaching assistants and public health workers and college and university professors and public health researchers, doctors and nurses, all of these folks to whom the promise was made, if you go into these occupations, you are not going to be struggling for the rest of your life with student loan debt that you can't get rid of. And that promise has been broken dramatically over and over again. That's what brings us to it as an organization, to our advocacy to try to fix the system, make it more navigable while it's still broken, and to hold bad actors accountable over the long term.
Thanks so much, Alyssa, and thanks for sharing your member story. That is probably the 10th time I've heard the Palomar nightmare story, and I feel like every time I hear it, I get fired up all over again. This is really wrong. It's not both just like legally wrong, it's morally wrong, and I think we're all so lucky to have AFT fighting on behalf of its members, because that voice is kind of so badly missing so much of the time in DC. I'm going to use a little bit of my moderator privilege here and provide a really short overview of the paper that I contributed to this series. So I'm also one of the paper authors in this set of research that we released. And I looked at the HEROES Act and the intersection between the HEROES Act and the Public Service Loan Forgiveness Program, along with my colleague, Rebecca Marr, who also works at SBPC. And we came to a kind of a similar conclusion that the Persis came to in looking at the statute and realizing just how far astray the administrations of both parties, going back to the Bush administration, have been in implementing public service loan forgiveness. And we reached that conclusion on a few fronts. One of those is exactly the kind of scenario that you just described, Alyssa. And I'm really eager to hear Shannon provide some more color around how that operates on the industry side too, as an enforcer. But people just seem to get stuck in the process of chasing paper around the student loan system. That's true for public service loan forgiveness. It's also true for all of the programs that we've all looked at in our research. And the HEROES Act really gives, so as Mike mentioned, there's this opportunity that's been in place basically since 9/11 to provide administrative relief for military borrowers who are affected by the authorization for the use of force after 9/11. But since March 13th, 2020, there's actually been a similar ability to just cut through this red tape that's available to everybody. The HEROES Act also says that in the event of a national emergency, the Secretary has this incredible authority to waive pieces of the law and waive pieces of the regulation to make the system work for people. And so the kind of a nightmare that you just described, Alyssa, seems like a great case study in the sort of things that the Secretary of Education could do tomorrow or on day one of a Biden administration to make these programs work properly, and to do that through automation, accessing data and records that are already in the government's possession, already in servicers' possession, to make sure that they're checking boxes on behalf of borrowers instead of forcing borrowers to check their own boxes and needlessly rejecting paperwork over and over again. And kind of adjacent to that point, we are in an emergency that is also a public health crisis. And for reasons that have never been clear to any of us doing this work, the Bush administration back in 2008 made a decision to exclude public health workers from public service loan forgiveness if they were working for an employer that was not a nonprofit. So our healthcare workforce, I think as all of you guys that do this work know, and so many people on the audience today know, really is kind of bifurcated. You have elite healthcare workers, like doctors in particular, that are heavily credentialed and also heavily indebted and very much benefit from PSLF because it allows them to serve in primary care, in underserved professions, in underserved communities. But you also have this frontline healthcare workforce that is disproportionately female, it's disproportionately Black and brown, and it's disproportionately employed by for-profit employers. And so by this policy choice a decade ago, we've actually excluded the people that are working on the front lines, helping people in the middle of this pandemic. And the Biden administration has this incredible opportunity to take a fresh look at that set of requirements and restore the promise of PSLF for the people that are putting their lives at risk, helping us get through this moment that we're in. So I just wanted to give a plug for our research too. If you're interested in learning more, you should check it out. But I want to keep the conversation moving forward. And I do, Shannon, want to give you an opportunity to talk a little bit about your background as a public enforcer, what you've learned bringing student loan servicing cases, and a little bit about the intersection between industry practices, the government bureaucracy, and the law.
Yeah, thanks, Mike, and good afternoon, everybody. My name is Shannon Kavanaugh. I'm the Deputy Division Chief of the Consumer Protection Division at the Massachusetts Attorney General's Office. And my office has been a leader in protecting student borrowers. And today I'm going to specifically talk about student loan servicing actions that my office has taken. We both can bring enforcement actions and conduct investigations under our power under the State Consumer Protection Statute, Chapter 93A. And we have done so. We brought, I think, the first state AG lawsuit against the Pennsylvania Higher Education Assistance Agency for its failure to administer the Public Service Loan Forgiveness Program. And we also brought an investigation that we settled several years ago with Xerox Education Services, formerly known as ACS, focused around their handling of the income-driven repayment plans. But we also have a unit in our office, the Student Loan Assistance Unit, that is hearing directly from individual student borrowers. And they have fielded thousands of complaints and inquiries from Massachusetts student borrowers. And what's important to note, and I just echo all of the views and points that my colleagues here on this panel have made so far. But what's really important to note here is when student borrowers individually contact our office seeking help, it's because they've exhausted all other lines of communication. They have already been in touch with their student loan servicers. They have already spent a lot of time and energy trying to figure out these problems themselves, trying to get basic information, not only about the programs that are best suited for them, but also basic information about their loan accounts and the status of their loan accounts. They've oftentimes been through the Department of Education's ombudsman's office. And so there's a huge failure here, both on the servicer's part and so far in the last several years on the department's part to do their job to make sure students have basic information and access to information in order to navigate the system. One of the things in our work here that has been really, really difficult when you ask, why things are so bad. Our office has gotten such incredible resistance from student loan servicers and the Department of Education when we have tried to get involved to advocate for student borrowers and to try to fix and assist to make systems better and programs more available for borrowers. In litigation, there's been very aggressive litigation. Just by way of example, when we did bring our lawsuit against FIA, the Department of Education, that was not a party to our lawsuit, stepped in at the 11th hour, a day or two before our motion to dismiss hearing, and showed up uninvited. The Department of Justice walked into the courtroom and they had filed a 30-page statement of interest on behalf of the Department of Education, arguing that our complaint was preempted. But they couldn't even make that argument in the statement of interest. They said, to the extent the Commonwealth is alleging X, then it's preempted, because we didn't allege the things they said for the very purpose of avoiding preemption arguments. So we're just hit from all sides in trying to make progress on these issues in litigation. The fights with respect to preemption, Privacy Act arguments, where we're trying to get basic borrower level information in order to be able to review it and identify where things went wrong to get relief from borrowers. We've just had so many walls thrown up at every angle. So one of the recommendations that I have is going forward, hopefully we'll have a much more collaborative relationship with the Department of Education in order to be able to bring some accountability to the system. But the other point that I'd like to make that we've talked about a lot today is the borrower burden. And I break this down into two types of burdens. There's the administrative burden that a lot of folks have talked about. When I hear stories about forms, my blood pressure goes up. It's, when I explain it to people, people usually can relate, even if they've never been a student loan borrower, to their worst customer service nightmare. And I say, well, what if that worst customer service nightmare can lead you to financial ruin? And that just, exacerbates this problem so much, because when borrowers are making these choices, for example, to participate in public service to help our communities, and they look to programs like the Public Service Loan Forgiveness Program to ensure that they can be financially successful, the choice they're making is twofold there. It's not only to participate in public service, but is to make a very dangerous financial decision that many people outside a promise of loan forgiveness would never recommend a consumer to make in any other financial transaction they do, which is to not make payments that amortize your loan. And so when you participate in this program and you're making payments under an IDR program, then your loan balance is ballooning. And if you can't make it to the end of 10 years, and I'll get to this later with some policy suggestions, then you're ending up with debt that is significantly higher than what you took out in the first instance. And there is your financial ruin. It's not simply that you haven't made progress in what you borrowed, you owe a lot more. So it's very dangerous. So these administrative burdens with respect to forms have severe consequences. But the other burden that borrowers face that's extremely important, and that's why everybody's work here is so important, is what I would call an advocacy burden. The work that borrowers have to do to figure out when something isn't right, what went wrong, why it went wrong, and to get relief is, and I think Mike mentioned this earlier with some of the military servicemen and women, it's a full-time job for borrowers to have to figure this out. And I have heard directly from borrowers, and these are borrowers that have degrees, these are lawyers, these are people who have resources to figure this out, that have taken so much time and energy and they can't get relief. And that is because they can't get information. There's a lack of transparency. They can't, and I'm not even talking only about what we would consider to be unfair and deceptive acts and practices. I'm talking also just very generally about errors and a failure of communication and a lack of transparency. And borrowers are put in a position where they have to navigate the system that they're not privy to how it works. They don't know what the internal operations of their servicers are. They don't know when they call up to say, hey, you might have, put my form in this IT system over here and failed to date it correctly. So instead of showing up, as my IDR plan starting on December 1st, it's going to show up on March 1st. And they're just not in a position to get errors corrected. So another recommendation that I can talk about in more detail later, which would be a kind of retroactive fix to the current program as it stands today, and I'm talking about PSLF, but also IDR, is hire an independent auditor to get in, look at these accounts, do a full-blown audit, identify errors, and then correct those errors, correct them to the benefit of borrowers, and take the burden off borrowers to have to try to go in month by month to figure out why they missed each qualifying payments. It's clear that these loans have been misserviced. And when one error happens on a live loan with these programs that are already so complex, there's a ripple effect, and it causes another one and another one. So the whole paid ahead status, you get overbilled one month, so you pay twice and you get put into paid ahead status. That won't count as a qualifying payment towards PSLF. There's no way that a borrower has control over that situation. So I would say, again, why things are bad. There's a lack of auditing. The Department of Education should have been more involved over the last several years in auditing and more extensive auditing and oversight and limitations in servicing systems. There are frequently IT glitches. By way of example, when Ed tried to roll out the IRS tool a couple of years ago, the software system didn't work, so people couldn't automatically get on to IDR, and they suffered delays and they lost qualifying payments. It's all well and good. We should be trying to automate processes more to avoid errors, but that's going to cause glitches. And that's okay if the glitches get fixed and the errors caused by the glitches get fixed as well. And instead, borrowers are just required to come forward and advocate for themselves. And at the end of the day, the current Department of Education does not permit loan account corrections for every type of servicer error that might have occurred, even if that error is undisputed in the context of PSLF. And even where, in our view, there's been an outright unfair deceptive act in practice, like a misrepresentation, there is not a fix that the Department of Education will necessarily provide for borrowers in order to get their qualifying payments back, depending on the type of misrepresentation. So that's another recommendation, which is to have a much broader view of errors and when borrowers can get fixes and what those types of fixes can be.
Thanks so much for that perspective, for helping us understand the difference between consumer protection enforcement and the kind of policy change we're all calling for at the federal level, and for giving me the term advocacy burden, because I think that really captures a lot of the work that that all of us do. And maybe I'm gonna just turn that to the rest of the group. I think grabbing on to that concept, do others have thoughts on where you see the programs you're experts in having this kind of disproportionate advocacy burden that could be overcome through smarter rules or better federal policy?
So maybe if I can jump in on that, and certainly, you know, one of the things, in terms of this information gap that folks have, right? Like one of the issues that I try to address is that folks don't know that income during payment is an issue, right? And our system relies on borrowers to be experts at the student loan system in a way that they just physically can't do. And our system forgets that you don't know what you don't know. And so we work with borrowers time and time again who don't know that income during payment is an option, right? So, you know, the typical borrower that we see has deferment forbearance, and then they default, right? Because they've run out of deferments and forbearances. And so they had to interact with their servicers in order to get these deferments and forbearances into place. And yet they weren't given the tools in order to access the program that actually would have done them some good. You know, I just this morning was emailing with a legal services advocate whose borrower had been in this deferment repayment limbo since 2006. They have somehow stayed in good standing since 2006 and have never accessed income during payment. Like I don't even understand how they have not run out of you know, deferments and forbearances in that time frame, but that's a story that was just this morning, you know, like we could talk about last month, the stories that I heard, but borrowers just don't know what they don't know. And the people who were paying, you know, hundreds of millions of dollars in order to tell them aren't getting that job done. And I think it does take, I know for myself, right? Like when I have had problems, I'm actually, I think a member of one of the AG's suits that they're doing, but you know, it took me 7 months to get my loans out of IBR and into repay. And in that time frame, right, like my loans were in an administrative forbearance, they slipped into delinquency. Like I probably logged about good 40 hours to try to get that fixed. And who has that time and that knowledge to know, right? We write a book on student loan law, and so I'm fairly well versed in how the statutes work. And it took me 40 hours to move through the process and get that fixed. And so I think that's why, just to Shannon's point of, the advocacy burden is just too much for borrowers to actually reasonably go through themselves.
I think if I could just add, to sort of make explicit what's implicit in that pattern of deferment, forbearance, and falling into default, there's also tremendous psychological burden associated with this. There is enormous shame for people around their student loan indebtedness. There is particularly huge shame around parent plus loan indebtedness, because parents have got giant feelings that come from completely understandable places about the fact that they were not able to do the thing that they were told they were supposed to be able to do and pay to send their kids to college as a lever of class mobility in the first place. And so when people are trying to overcome these advocacy burdens and make the time and the space and secure the knowledge to advocate for themselves, they are also pushing uphill against a really, really powerful set of disincentives. One of the things that we found helpful in the debt clinic program at AFT around it was just that people were in a room together, and the way our clinics are set up, people get information for like the first 45 minutes because they have to be talked to about the fact that it's not their fault, and like get comfortable enough with receiving all the information about how the system is broken before they're willing to start kind of popping up and saying like, this happened to me, and being angry about it. It helped a lot to mobilize people. And I think this political moment of talking about cancellation is doing some of that work even for people who aren't in a room together. Because even if you just catch, on the front page of the New York Times today, somebody's talking about debt cancellation, it gives you a sense of like, wow, something like maybe this isn't just me. Maybe this system is really messed up. And I think that's part of what makes this moment so powerful.
Go ahead.
No, go ahead, Mike.
Oh, sorry, Bethany.
Just to piggyback off of what everybody's saying, I mean, the conflicting incentives that people have, if you have the wrong type of student loans and you're trying to get into PSLF, you would theoretically consolidate with a direct consolidation loan. In the military, if you have those student loans prior to joining, you have Service Member Civil Relief Act rights that are that go away after you take out that consolidation loan. So that you have to choose between having an interest rate cap on your student loans while you're in the military, like Congress intended, or participating in PSLF while you're in the military, like Congress intended. There's literally a no-win situation there for them. And I know, speaking of individual examples, I know of another individual who has been out of law school for 23 years, has worked for the Army probably the entire time, but consolidated his loans before PSLF came into effect. So he is locked out of PSLF and is just the quintessential person who should have had their student loans forgiven before. So it really does cut across the entire federal student loan borrower community.
And I'll just add that oftentimes the information is already there, and you are being asked to submit information that the government or the servicer already has. I experienced that personally as well, but for folks who are on Social Security disability, they already report their income every month. It's not actually like they're used to filing paperwork. By and large, they do that with help of legal services attorneys or have regular processes there. And then to turn around and have education ask them for that information again it's frustrating for me when education's like, hey, can we check with the IRS about something? But at least I understand they're asking for my permission to share information when it's already information that everyone has, and Ed and SSA are already sharing all this information. The fact that they can't just use the information that they have to automate the process and to make it simpler for everyone involved is does not make any sense. And anything the administration can do to simplify that is going to be a huge step in the right direction.
I think that's a good segue for my next question. So everybody who's written papers here, but I think all of you that have kind of worked in the trenches on these issues for so long, had really good, concrete, tangible advice for specific steps the Biden administration can take to drop these administrative burdens, to automate the process, to help reduce the advocacy burden on borrowers. So maybe we can go through anybody that wants to jump in, the one piece of advice that you would give to the Biden administration right out of the gate to help your constituency make heads or tails of the system.
I mean, I think you have to get agencies to talk to each other. That has been, I think, the barrier for so many of these programs, right? We can't automate, annual recertification of income during payment because the IRS and the Department of Education won't talk to each other, right? It took a lot of work to get the Department of Education to talk to the Social Security Administration and to the VA, right? But it did happen, and so that's actually, I think, I don't know if we want to call it the promise, but certainly like it's possible. And so they just need to, and I think it needs to come from the top. I think it probably does need to come from the White House to say, this is a priority for agencies to actually talk to each other, which doesn't seem that radical when I say it out loud, but truly is one of the barriers in terms of getting a lot of these processes just to frankly work.
And we need them to follow the statute. I mean, with the TPD program, it's very clear. As long as you have been on Social Security disability for 5 years, you meet the statutory standard. But there are people who have been on SSDI for decades who aren't getting their loans discharged. That makes no sense. And we need to take a good hard look at what the statutes are and go back to what that is. And we're in a very unique moment with the authority under the HEROES Act and the pandemic right now to help all of these low-income borrowers who will put the money directly back into the economy and start motivating that type of spend that we need to get the economy running again.
Yeah, and I would say, specific with PSLF, go back to the legislative intent. Go back and look at the legislative intent. And if a borrower is working in public service and making student loan payments, that borrower should be getting the benefit of PSLF under the current program. But the program should be looked at, in my opinion, prospectively, to think about the 10-year requirement of the program. And I think that loan forgiveness, if there is going to be a 10-year requirement before you finally get loan forgiveness, and maybe it should be a shorter period of time, but if they are going to keep a 10-year requirement, loan forgiveness should happen incrementally. Borrowers should not have to just wait until they've made it through all the minefields and 10 years later find out for the first time whether they're going to get the benefit of the promise of the program. They should be getting incremental loan forgiveness either on a yearly basis or even better on a monthly basis. That's what qualifying payment is. You're making payments towards loan forgiveness so that these loan balances, they don't have the burden of having these loan balances grow with the stress of trying to navigate the system, and they're performing in public service. It's valuable every month they perform in public service. There should be some kind of benefit there, which is what the intent of public service loan forgiveness program is. It's encouraging people to come and to make a commitment. And whether that commitment is 1 year or 10 years, it's still benefiting our society. It's still helping the people who need the most help in our society. And there should be, the program should be geared towards that goal.
And I think that's a great segue to the political moment that we're in right now. So my colleague Tarek mentioned on the first panel today that we have a president-elect and a vice president-elect that expressly campaigned on providing debt relief to student loan borrowers. And exactly the kind of policy change that Shannon just mentioned on public service loan forgiveness, that was in the Biden campaign platform. The Biden-Harris campaign proposed offering public service workers $10,000 per year for working in public service for the first 5 years of their public service as a supplement to the existing public service loan forgiveness program. I think when that particular provision was announced, it was anticipated that that would be a legislative change. But one of the things that seems to me, at least, like the real opportunity that we're in is that you can make those kind of restructuring decisions, particularly if you're doing it backwards looking. If you're going to take that framework and use it to repair the damage that's already been caused to the Public Service Loan Forgiveness Program, we should look to what the president campaigned on, and the president-elect campaigned on, and we should try to kind of use our imagination and use the law to be able to deliver on that promise. So I do think it's really it's exciting that we have a president-elect and a vice president-elect that campaigned on fixing these programs, like this very wonky, arcane piece of student loan law that we all live in was front page news for a while. It continues to be front page news, and that's a real opportunity for all of us. So I think maybe to round us out here, we have an audience of scholars and activists and student loan lawyers and individual borrowers that have now tuned into 2+ hours of a very detailed conversation about how to fix the student loan system. And we still have hundreds of people that are joining us for this discussion, which is incredibly exciting. Can you guys give some homework out? So to the scholars, to the activists, to the advocates, to the lawyers, what are the things that they can be doing to help push this forward, to give President-elect Biden and Vice President-elect Harris the tools they need to be able to take action? What's missing from the public discussion? What research needs to be done? What lawsuits need to be brought? What stories need to be compiled? What comes next?
I'll go first. So, frankly, the absolute numbers of active duty service members who have student loans. I mean, we don't. The best we have is what I said earlier was a CFPB estimate from roughly 2017, and they had to do some serious forensic analysis to come up with that number. So the secretary should match student loan records against active duty service records already available to Ed, so that military borrowers can receive their PSLF credit. Yeah, we just don't even really have the full idea of how big a problem this really is.
If I can piggyback off of that suggestion, like one of the things that we don't actually know. So part of my paper, what I tried to do is kind of come up with categories of people who we should dig back through our records and figure out we can dole, forgiveness out to or cancellation to these borrowers immediately on day one by looking backwards. But we actually don't have a lot of information in the public sphere about these loans. And some of the things we don't know is like, what is the point? What borrowers never repay their loans? Like, it seems to me that there's a pool of borrowers for whom it makes no sense to continue to collect on their loans for 20, 25 years. So we need more data about the characteristics of just the student loan portfolio so we can start making better policy decisions. And then, I think we need to think big too, right? Like, let's not have this conversation in a vacuum. It has in the cancellation, right? Like, we're in a cancellation moment. We should have widespread cancellation. We should be working towards a, debt-free higher education policy. And so, I think that income-driven repayment is critical until we solve those problems and eliminate student loan debt altogether. And then my last plug is that just don't forget Parent Plus borrowers, because they get left out of the conversation, and it is one of the populations that I struggled the most to figure out how to get them included in a cancellation program. So think about Parent Plus borrowers.
And building on that, I'd love to see numbers for retirement Social Security beneficiaries who are still have student loans or Parent Plus loans pending, because I'm sure there are lots of them, and I tried to find that number and I couldn't. And the OIG office at Social Security has pulled some of the ones that transition from disability to retirement, because you can kind of do that math. But I want to know how many retirement are, because I'm sure that those folks, if we're going to target another population, that's a population that are by and large very low income, or relying on very limited means. And yeah.
I feel like this is giving myself homework a little bit, but to the other, enforcers and litigators out there, you know, to make a real, there's so much secrecy. There's so much just hidden from the public view. And we have the benefit of discovery in our cases and in our investigations. And to the extent that the battles can be fought and won with respect to confidentiality and getting as much discovery and information that we can out on the public record, so that there is no longer this, you know, secrecy. What's the contract that the Department of Education has with the servicers, you know, by way of example. There's information, you know, to be had that litigators have a special tool for being able to obtain. So to the extent as much of that can be made available publicly, we should be working to do that.
I think I would like to just kind of underline and amplify what Persis said, which is that, you know, we have this opportunity because there were roughly 8 million more Americans who wanted to double down on democracy than whatever the heck we were headed for, having not done that. But we cannot have the kind of democracy that we want to have in a system where all of our higher education costs are privatized and turned into debt. It's just not, like, it will not work. So this has to be, this conversation about cancellation and about student loan indebtedness has to be tied to the conversation about how we're going to pay for higher education going forward. And it's actually one of the things that excites me about it the most is that I think any amount of cancellation, whether it's 5, 10, 50, or all of it, is going to help push people toward having that larger conversation about how we don't have the same problem again going forward. So I want to invite everybody who's listening into that conversation about how are we going to undo the privatization of higher education costs in the future.
Those are amazing concluding thoughts from all of you. I want to thank you all for joining us for this discussion today. Thanks for tuning in to everybody that's watching this panel and our program at large. Check out the papers that everybody wrote. They're available on protectborrowers.org. Thank you again also to our partners at UCI Law for working with us, and to Demos for co-hosting this event with us. And we will be back in just a few minutes with our last panel of the day. So thanks, everybody.
Thank you.
Welcome back for our final panel of the day entitled The Equity, Economic, and Policy Case for Administrative Action to Cancel Student Debt. This panel will be moderated by Dalia Jimenez, professor at University of California, Irvine School of Law and co-founder of the Student Loan Law Initiative. Dalia, take it away.
Hi, everyone. Thank you for joining us and thank you for sticking around. I see that we have over 150 people. That's fantastic. So I direct the University of California, Irvine School of Law Student Loan Law Initiative, which is a partnership with the Student Borrower Protection Center and the only academic center in the country, I think still, dedicated to producing the highest quality academic research on the student debt crisis. So, and I'm really excited to be here and grateful to the Student Borrower Protection Center and DEMOS for putting this on. So in the first two panels, you heard about program-specific cancellation for students defrauded by predatory schools and for vulnerable students, including public service workers and military families. And there was a reason we started with that rather than what is more headline catchy, broad-based cancellation, which is what this panel is about, right? This panel is entitled The Equity, Economic, and Policy Case for Administrative Action to Cancel Student Debt. The goal of this panel is to think about these broader forms of student debt cancellation. But just to make it very clear, to push for something like this, broad-based cancellation, does not exclude or ignore the other types of relief available to the Department of Education and to Congress and to the new administration. We view broad-based cancellation as complementary to the other programs discussed in the earlier panels. It's not either or, it's both and. And in fact, the point of this panel, or part of the point, is to help us explore the way these approaches are mutually beneficial. So we have 6 very accomplished and great panelists today who have a lot of knowledge in this area and not a lot of time. So to save some time, I'm going to just introduce them to you as I ask some questions. And so we're going to start with Ashley Harrington, who's the Federal Advocacy Director and Senior Policy Counsel at the Center for Responsible Lending, who wrote the introduction to our Delivering on Debt Relief compendium, along with Mark Hulsman, who we'll hear about from later. Ashley, thank you for being here. Can you tell us a bit about what you wrote in your article and how student lending speaks to your equity work at CRL?
Absolutely. Thanks so much. And thanks for having me here today. And we were really excited to write this introduction. So at CRL, we're committed to narrowing the racial wealth gap and ending predatory lending and really helping people of color and low wealth families have real opportunities to build wealth. And part of that is ensuring a fair and inclusive financial services marketplace. That's really central to that mission. And so student debt plays into that because it is, as we watch how the racial wealth gap has persisted over time due to federal policies and federal action or inaction to actually address all of these issues. Now we have student debt both exacerbating the racial wealth gap while it's also a product of it at the same time. And so we began to look at what was happening with higher education and how we finance it. It started with looking at servicing reform and for-profit institution accountability, but really went beyond that when we looked at the real impact that student debt was having on people's ability to build wealth and for particularly Black borrowers to get that return on investment that I think most of us would expect to have on higher education. So in this paper, Mark and I really tried to delve into how we got here and just how far our higher education system has gotten away from the dreams and ideals of Lyndon B. Johnson when he proposed the Higher Education Act in 1965. The promise has really not been met. It was never supposed to be a system that was based on debt. It was supposed to be a system of grants for low-income students and students of color. It was supposed to be about access and opportunity, not debt and devastation. And so we've watched how this played out, and that was in 1965. And then we get to the Great Recession and all all of the impact that it had on communities of color. And we saw communities of color lose over $1 trillion in wealth that has never been regained, even as some say the economy has recovered and that we had bounced back before we got to the current recession and pandemic. But that was not the case. That was not the case in so many Black and brown communities across this country. And then as we entered that Great Recession and that wealth was lost, and we also saw state higher ed budgets get cut, and more of the cost of higher education being passed on to families and really burdening even more families of color, we have a real problem. And so we tried to delve into that. We looked beyond that. We looked at, how we funded or didn't fund our HBCUs historically and how we continue to underfund them. We looked at the fact that the GI Bill, which was one of the first ways that we gave people opportunities to access higher education, disproportionately didn't go to Black Americans. And so all of these things have contributed to this racial wealth gap and to the compounding of these inequities. And now we're here with a $1.7 trillion crisis that is disproportionately harming Black and brown people. And we have a need to address that. This time is not here to tinker at the margins, to play around the edges and think that that will actually provide relief to borrowers. Black borrowers need so much more than that. They need actual broad-based cancellation because this debt should have never been amassed in the first place. We should all be concerned that 45 million people have $1.7 trillion in debt, and we should be particularly concerned when Black borrowers are bearing the brunt of that crisis. And now that we're in the COVID-19 pandemic, we're seeing the recession and the public health consequences also disproportionately impact these communities. We should be even more concerned, right? We're going to come out of this and we don't know if and when recovery will start, and we don't know if it will be inclusive or not inclusive, but we know that part of that answer has to be doing something about student debt, because it not only will help the borrowers, it will help the economy, right? It's a twofold piece. And so thinking about the fact that, President-elect Biden in his campaign talked about the need for COVID relief, for economic stimulus and racial equity. And this is that solution that gets at all of those that he can do on his own with executive action without waiting for Congress. And so I think that is really how we approached it. And I will stop there.
And thank you. That was really great. And I just want to put another plug in for the compendium, which has the article that Alexis was just talking about, and as well as many others, and including one from Jake Brooks, who is a professor of law at the Georgetown University Law Center, and also contributed a paper to the compendium about the very exciting topic of tax. And I don't mean that in a sarcastic way.
Thanks, Dahlia. And thanks to the Student Borrower Protection Center and to the SSLI for hosting this program. It's really great to be here. I'm going to be brief because there are so many important voices on this panel that we all need to hear from. But I do want to address the tax issue because it's important to the efficacy of the overall idea of debt cancellation. So there's sort of a conventional wisdom out there that the student debt cancellation would be taxable. But I think that this is based on a misreading of the history and the law on this issue. And as I said, it's critical to get this right, since a failure to do so could really undermine the benefits of cancellation. I mean, if we tax people on student debt cancellation, that essentially means that the government does not actually cancel all the debt. It only cancels some of it and then accelerates the rest. And this is also, not incidentally, a critically important issue for the success of the income-driven repayment program, where we may see very large cancellations down the road with potentially very large tax bills as a result. And it's also important to get this right because critics of cancellation have been citing the tax law as a reason not to cancel debt in the first place. But thankfully, there is more than sufficient legal authority in the existing tax law for the IRS to rule that student debt cancellation is not taxable. So first, for decades, we had a history of treating student loan cancellation as a non-taxable scholarship. Scholarships are explicitly excluded from taxation in the tax code, and the IRS correctly viewed student loan cancellation as akin to a scholarship. That appears to still be the authority, by the way, today for not taxing student loan interest subsidies and waivers. Now, the legal issue on this got a bit confused in the 70s and 80s in a way that my paper discusses, but the underlying law and logic is still sound. the bulk of any canceled student debt should be considered a non-taxable scholarship payment. Second, many government payments for the general welfare are excluded from taxation, such as housing subsidies, food stamps, vocational training, payments to victims of crime, and many other things. And the same should be true for debt cancellation. This is particularly in the context of COVID, because the tax law is very strong on the idea that a qualified disaster relief payment is non-taxable, and the COVID pandemic has already been declared to be such a qualified disaster. If cancellation is connected to the economic devastation of the pandemic, then non-taxability is clear. Third, from a tax law standpoint, student debt is actually really complicated because of the many borrower rights baked into the loan, especially the ability to fully discharge a loan by making 20 years of income-based payments. This makes it not obvious at all that debt cancellation, student debt cancellation, is equivalent to, say, reducing mortgage or credit card debt. It's even questionable to me whether an income-driven repayment student loan would be considered debt for tax purposes. So for these and other reasons, the IRS has the authority they need. Now there's a precedent on this. So the IRS has already created a safe harbor against taxation for borrower defense discharge, where that safe harbor is based on the fact that there is a series of legal arguments that would likely apply to almost all the relevant borrowers, even though the IRS couldn't necessarily say for sure which argument applies to which borrower specifically. But they said the sum total of all the arguments is sufficient for us to decline to assert taxation. The situation is even clearer here, in my view. Borrowers have multiple strong legal arguments that any student debt cancellation should not be taxable, and the IRS should make that clear. Thanks.
Thank you. It's really important because, I mean, we've got to, I think part of what we can do here, as you know, with all the experts we have in the room, is to really examine both how do we make this happen and what are the effects of it, as well as you know, the potentially good effects, the potentially negative effects, and the ways in which we could ameliorate some of those potentially negative effects. Thank you. So I want to tackle some of the elephants in the room that you know, we started with. We started with Ashley talking about the student, how student debt has really exacerbated the racial wealth gap, and how it has let down a lot of our Black, particularly Black, but also brown borrowers in this country. And one of the reasons given against broad-based cancellation is that the racial wealth gap is actually not going to be, you know, decreased. It's that it's going to be exacerbated. So sort of the opposite, right, of what we're talking about here. So Joanna, I want to ask you if you have any thoughts on that, and whether you think that does the research actually support that interpretation? I'm sorry, and Joanna, I should say, Joanna Dargis is a staff attorney at the National Consumer Law Center. I forget, I have to introduce every time. Okay, Joanna, please.
Happy to be having this conversation with you all today. It's vitally important that as we think about debt cancellation, we really lean into how necessary it is to move for broad-based debt cancellation. That is the pathway to equity here. So if we want to reach the very borrowers of color who are struggling with student debt right now, we have to make sure that we don't leave them out. And that means if we want to carefully target them, we have to cast a broad net. And that means that that's how we'll make this program effective. We've heard all day today about programs that have been narrowly targeted and still haven't met their mark, have still failed to deliver relief. And being efficient and effective here is the way to get the relief to Black and brown borrowers. And that's why we need to pursue broad-based debt cancellation. When I think about the ways in which some have said that broad-based debt cancellation would potentially exacerbate the racial wealth gap, got to remember that we are talking about we have to, a lot of times the conversation about wealth and income get conflated. And we really, really want us to stop looking at means testing as a way to make debt cancellation more equitable when we're looking at income as a proxy for wealth, because they're different. And we're really talking about not just how much money someone's earning today, but about whether their family has historically been deprived the opportunity to build wealth, to get high earning jobs, to access higher education. So canceling debt in a broad way is how we would make sure that Black and brown borrowers, the people of color who have taken on a disproportionate burden of debt, will be well served by this program and by the policy behind access to higher education in the first place. You've got a mountain of debt in the first place, then that's not really what affordability is, and it will certainly impede the ability to build wealth. Here, being inclusive is the way to address the racial wealth gap. And it's not the only policy we need to implement to address the racial wealth gap, but this is where in the student loan space, to the extent that student loans have been a driver of the racial wealth gap, and to the extent that income and family wealth doesn't protect Black borrowers from facing default and the negative consequences of borrowing, we need to make sure that we do what we can do in the student loan space and cancel the debt. That doesn't mean that we don't need to continue talking about reparations. That doesn't mean that we don't need to continue to talk about wholesale policies that will also invest directly in the Black community and in people of color. But broad-based debt cancellation is a good start, and it's something that's immediately actionable in the student loan space.
Thank you. Yeah, that's actually a great point as I want to transition to the broader question of sort of the regressivity argument. Both when making those arguments, people who make them, generally speaking, are in the racial wealth gap argument, they're basically ignoring all the other possible things that might be done and saying, like, this isn't going to solve it. Like, well, not one thing is going to solve it. It is, hundreds of years in the making problem is not going to be solved by, something that is so, in a way, small relative to the larger problem. But it is a step in the right direction. So another argument that often comes up, and in fact is probably, if you just Google student debt cancellation, one of the first, all of the articles that you get at first are about, well, it's regressive. It's not a good idea because it's gonna not help. It's gonna help more the people who don't need the help. And there've been lots of articles making this claim, although looking at who's written them, I'm not really sure that those people would be supporting any kind of debt cancellation. But they would just be arguing, so it's sort of I don't know if it's it seems a little disingenuous, but I'm an empirical researcher, and so I want to pose the question to Alexis about data and whether there is data supporting the view, or whether or contrary. Alexis Goldstein, who's a senior policy analyst at Americans for Financial Reform. What do you think?
Thanks so much, Dahlia. Yeah, I think my short answer to this is no. Federal student debt cancellation is not regressive, and the data does not bear that out. I think the main mistake that people make when they approach this is they're looking at amount of debt instead of number of people who are helped and where those people are on the income quintiles, right? Are they in the top 20% or the bottom 80%? And to sort of Joanna's earlier point and Ashley's earlier point about $1 trillion in Black and brown wealth just being completely lost in the years after the Great Recession, right? Income is a bad proxy, right? We should be talking about wealth, but we have the income data, so that's unfortunately what I'm going to be using. But if you look at $50,000, just to pick a number, of student debt cancellation, if we did $50,000 of student debt cancellation, 80% of people in the bottom 80% of incomes would have their debt completely eliminated. That is not true for the top 20% of incomes. They would only about half of them would see their debt completely eliminated. And there's also very particular benefits to people who are in default, who we know, generally speaking, are lower income people. A lot of people are in default on extremely low balances. The highest numbers of people in default are people who borrow a relatively small amount, which is less than about $6,000. And so even if we did a $10,000 in student debt cancellation, you would actually eliminate a huge amount, the majority of amount of people who are in default, who are suffering these very punitive, terrible consequences of default, like huge debt to income ratios, trouble getting jobs if employers are checking their credit. Sometimes you have your driver's license or even your professional license suspended. So again, the key mistake that people make is thinking about where the debt is and how much debt people have. And so yes, there are wealthy people that have a lot of debt, and maybe there's a lot of debt in that one wealthy quintile that gets eliminated, but that's not looking at the sheer numbers of people and the meaningful differences in their lives. A few other numbers just to put out here, and this is one actually compiled by Mike Pierce of the Student Borrower Protection Center using someone else's data, but 57% of people who are currently unemployed, so the sort of COVID unemployed, 57% of them have attended at least some college. And that's another just thing that people don't think about when they think about student debt. I think they have this picture in their mind. It's someone who went to a college and lived in a dorm. There are so many people that have different experiences. Maybe they have a 2-year degree. Maybe they did not complete. There's a lot of different experiences that people have with higher education. And more than 40% of people with student debt do not have a college degree. So either they are a non-completer or they have an associate's degree, but 40% of people who carry debt don't even have a college degree to show for it. And to the sort of racial disparities that Ashley was talking about earlier and Joanna was talking about, right? We know when we talk about regressivity, student debt itself is regressive in that way, right? Because Black borrowers need to attain higher levels of credentials just to get the same income levels in many cases of white college dropouts or white high school dropouts, right? So student debt itself is almost regressive. And so what does it mean to say that canceling some of it would be regressive? Like, you need to sort of ask the question at the right point of the problem. But I do think that student debt cancellation is not regressive when you just talk about the sheer numbers of people that it would be helping. And I do think that that is the right way to think about it and to approach it. And just to put one more finer point, because I'm talking about income quintiles, which is a little abstract. So people in the bottom 80% of income, right? You cancel $50,000 in student debt, 80% of them have their loans wiped out. That's people with less than $111,000 in income, just to put a little more precise of a note on it. Thanks.
Yeah, thank you. Yeah, some of these arguments just don't seem as sort of serious, I think, when we really examine them and when we look at the actual data. But there have been these two numbers thrown out, the $50,000, which is actually Senator Warren's proposal. I think there's a bill before Congress, and then the $10,000 that President-elect Biden has promised before. How do we balance that, Mark Hulsman, who's the Associate Director of Policy and Research at Demos, one of the co-sponsors of this conference? Thank you. How do we balance this sort of, number, broad-based cancellation with the program-specific cancellation that the earlier panels discussed? Can we do it all? Do we need to do something first?
Yeah, that's a great question. Thanks, Dahlia. I mean, the short answer, and I promise not to drone on too long, is we can do both. We can walk and chew gum, and frankly, we should. So obviously we've had kind of a whole half day here on improving existing programs, thinking more creatively and aggressively about them. That work is essential. It's hard. It's years-long work, and it sets us up for success going forward. The more we can sort of make those programs work and work well for borrowers who frankly deserved relief yesterday. What I think is kind of interesting about this often is like, there's this narrative around, or that sort of sets this up as oppositional views, right? Like cancellation gets posed as pie in the sky, program specific gets proposed as responsible, or the adults in the room. And and I think it's funny is that, it's often framed as responsible or sensible to expand or highlight or provide better information about existing programs. But we're like on our 9th iteration of IDR at this point. Like, issues with PSLF have been well documented. We're closing out an administration that viciously threw sand in the gears for borrowers who had applied for and deserved every drop of relief under BD, right? To the point that many have spent half a decade or more waiting or begging for relief long after their schools closed even. So like, this stuff is hard and necessary to untangle, but the point I'm trying to make is that it's no more reasonable to say that we should improve existing programs than it is to say at a time of extreme economic precarity that we should actually start over, and that for many people the risk has simply overshadowed the benefit, that 2 generation defining recessions in 10 years should make us err on the side of going bigger, having a reset, while we sort of, continue to improve the system. I think broad student debt cancellation does a couple things. One is that sort of ideally, and depending on how you do it, as Alexis was talking about, it gets rid of the debt or almost all of it for people who were most likely to default, fall behind, otherwise have to wait 2 to 3 decades for forgiveness or cancellation when they could have gotten it now. 2, as I mentioned, it sort of amounts to a reset and an admission that what we assumed about this financing instrument was not true, especially for Black and brown borrowers. And it moves us towards a policy conversation and a system going forward that, in which student debt, to the extent it does exist, is more humane, it's predictable, it's reasonable, it's frankly a choice instead of an obligation. And by and large, if we have broad-based student debt cancellation tomorrow, right? Depending on if it's 10, it's 50, it's all of it even. There either may be some debt left, and even if we do the right thing and invest in debt-free public colleges and make sure that we, eliminate every dollar of unmet need for people, there will be some future debt from those who maybe attend private colleges, maybe some graduate programs and so forth. And that's why we need the ability and sort of an aggression in canceling debt using existing programs in case future Congresses, administrations, states, institutions fail to deal with predatory actors or act in a way that are actively harmful to borrowers, which might sound familiar given that, we are still, in an administration that has done that for the past 4 years. So, I think the debate going forward is quite interesting. We have some really great proposals on the table, whether that's $50,000, whether that's $30,000, whether that's all of it. Ensuring the tax code is where we think about wealth distribution, a flat amount for everyone, an additional cancellation for those, in certain classes, incremental forgiveness, which has been mentioned. But I think that, given the persistent legacy of discrimination and wealth stripping from Black and brown families, the fact that, white households, even those with student debt, right, consistently get wealth passed down from older generations, and middle income Black and brown households specifically have just a fundamentally different financial picture. I think we can hold 2 thoughts in our head at the same time, that we can do a sort of reset, particularly given the economic situation, particularly given this crisis, particularly given what we've seen over the past decade or 2, and have the tools going forward to be able to nip this problem in the bud if it comes along again.
Yeah, that's really helpful. I just want to pick up on your point about this notion that the program-specific cancellation is the responsible thing or the adult in the room type of answer. But it ignores really, some of the people that Alexis was talking about, those who didn't graduate or those who didn't, who basically have really small loans that are not worth pursuing, that are really just, it's a waste of money to go after them and resources and, psychologically detrimental to those individuals to both have those loans and be pursued, for them. And that's not the adult in the room. That's just being mean, right? That's just wanting to punish people. And that really doesn't seem, just like a good use of anyone's time, really. And so, to the extent that that argues for some, just really erasing the debts of people with small dollar, especially if they started with, some of them may have started with $5,000, but now their debts may be much larger, actually. And so they might need those 50,000, even if they actually only spent, 5,000. This would be helpful, particularly to those individuals who, to talk about regressivity, are obviously, who needs to borrow to go to college or to go to a certificate program. It's primarily Black and brown borrowers because they need to, because they don't have the wealth to look to, right? And then when they are in trouble because they are, because those programs aren't good, or whatever other circumstances, don't have the wealth to fall back on to pursue, to be able to repay those. And so it was as Alexa said, regressive from the beginning. You know, and in particular, the programs and the broad cancellation would help those who probably need it the most. So I have sort of one other question to introduce the last person who hasn't gotten to speak yet, Luke Herron from Yale Law School, who wrote an article earlier last year detailing the authority that the Secretary of Education has to do a lot of these things that we've been talking about without necessarily going through Congress. And so Luke, I wonder if you'd give us some context about where we are now, you think, on cancellation versus where we were 6 months ago, a year ago, 2 years ago. What has changed, and does it, I think for me, it makes me hopeful, but you know, what makes you hopeful about progress regarding cancellation, but also more broadly about what Alyssa talked about in the earlier panel, about how we're gonna deal with this going forward. You know, whether, you know, cancellation, you know, is it just about cancellation? Do we think the movement is just for cancellation or for also, you know, not requiring people to incur massive amounts of debt before they can get a degree?
Thanks, Dahlia. Hi, everybody. Thanks to the Student Borrower Protection Center and to Demos for hosting this event. You know, maybe the best way to start answering this question is to say it's kind of surreal that this event is happening at all. My experience working alongside some folks here, including Alexis, is that, you know, I've been talking about student debt cancellation along with a bunch of folks from the Debt Collective and post-Occupy formation since 2015, and a lot of folks talked about it before. And in that time, it was crazy, ridiculous to even say student debt cancellation was a possibility of any sort, even to say that for-profit college students should have their debts all wiped away. So anyway, that's surreal, and I think that gives us a sense of the trajectory if we go back even before 6 months ago. I would say it's worth, before going through the sort of historical trajectory and where we are now, articulating why I think student debt cancellation makes sense, and try to cut the issue in a different way than to talk about just regressivity or progressivity, because the way that regressivity and progressivity are often conceptualized is as a way of characterizing a set of statistical aggregates, you know, where on the income spectrum relief is targeted. And so in that way, it treats student debt as basically just one among multiple aspects of a household's balance sheet. And the only relevant moral question is, how do we make these balance sheets more equal? And I think that is, of course, a relevant moral question, but it seems to me that the reason to cancel student debt should be more indexed to the question of, do we want to have a higher education system that puts people in debt? Do we want to condition the ability to access education, which really should be a basic human right? It's a basic aspect of human curiosity, creativity, of socialization, of working, of learning and being together in a democracy. Do we want to condition that on being indebted? And do we want to condition so much of well-being in our society on having an education? So the fact that the higher education system has been turned into basically a way that you make money, and then you go into finance and make a lot of money, for instance, is a corruption in some sense of the higher education system. And so to cancel student debt is best understood, in my view, as progressive to the extent that it dismantles this way of doing higher education and this way of organizing the labor market and the distribution of income and wealth. And so in that sense, I see student debt cancellation as a non-reformist reform, or best viewed as, or ought to be tried to be oriented towards being a non-reformist reform. That is a reform that is organized towards dismantling the way that we've organized higher education and employment and income distribution in the country. And so that, I mean, we can go on more about what that would mean, but I think that is a different way of asking the question of progressivity and regressivity than, you know, now we look at people's income bands, we look at people's wealth bands, you know, how does this leave people relative to, how does this leave the whole spectrum relative to what it was before? I think that's a very narrow way of understanding it. And thinking about student debt cancellation more broadly is also, in that way, also allows us to conceptualize it as, would student debt cancellation, this issue was raised up earlier, would student debt cancellation change the way people think about higher education, change whether they think they ought to be paying this debt, whether this debt ought to be incurred in the first place. That's a fundamental change that has only really recently happened as recently as like the 1990s, that people thought taking on debt to go to a higher education was a natural thing. And so can we start to change the way people organize themselves politically and think about higher education? So that way of thinking about things is the way that, you know, I come out of, and the way that the reason that I thought through these ideas, and the way that the movements that brought these ideas to the fore understood these ideas. So I think in part that was inherently crazy, because the nature of the debate 6 months ago was people who thought the system was mostly working just fine. And even people who are sort of towards the left end of what I would call mainstream policy discussion on higher education, the thought was the system is working just fine, except for-profit college students and students who have not completed their degrees, right? And that was actually a relatively recent innovation, as of 2 years ago, to even acknowledge at the bottom end of people, it's actually not worth taking on student debt. It was always just like, well, on net, it's a benefit to go to college and take on debt. The notion of canceling debt just didn't make sense in this whole framework. I think now we're at the point where increasing numbers of people are recognizing that student debt both is actually actively harmful, a net wrong for a lot of borrowers, and that what a lot of people have highlighted so far, that there's been such a repeated series of program failures that these incremental measures, even if in theory they're good ideas, which I mostly don't think they are not gonna happen, because they don't alter the dynamic of the political dynamic that reproduces the student debt system that exists today. And so there's a notion of, first, borrowers have just repeatedly wronged, let's wipe it out. And second, now we have to do something. Maybe I'm speaking too long, but the last thing I will say is that I think the moment, that's still like the left end of the discussion now, of the mainstream version of the discussion now. I think the center of it, people like, why is Chuck Schumer pushing this? Is basically because he wants a way to stimulate the economy that doesn't require going through Congress, and to do it quickly, which is like pretty opportunistic in a good way. I think we should just take advantage. I mean, that's one of the reasons that we're getting a lot of these debates, is like, this is not that great a stimulus relative to other possibilities, and this is not super progressive relative to other possibilities. I think that's true. Like, I think other medical debt, housing debt or rent payments are a lot more impactful on lower income folks in our society, and that like other reforms would be first order better. But we're in this sort of this world of figuring out what we can do given the political forces now. So it's in some sense it's like mismatching the nature of the debate with the nature of the political situation in which the debate is happening. But it seems like more and more people are getting on board. And so I would say I'm very hopeful. One thing that makes me very hopeful is to see something like Jim Clyburn saying, well, yeah, this might have legal challenges, but we have lawyers too. That's somebody who's not a super radical person saying something like, we have to go big, we have to take a legal risk, which if you had asked me 6 months ago if that was going to be part of the mainstream of the Democratic Party, even, I would said absolutely not. Even if Elizabeth Warren or Bernie Sanders had been elected president, I would have thought there would be resistance. So it's a potentially very hopeful thing that, just due to sort of a number of circumstances that we're in now, we'll see. I think we haven't seen the full force of the backlash yet, and so we'll see how that looks. So enough for me.
No, that's really, I'm now going to open it up shortly, and there's I know a lot of a lot of things have been raised by people earlier that folks want to talk about. Let me start with this idea of the simplicity of cancellation, broad-based cancellation, and the complexity of the programs. I think Alexis wanted to talk about that.
Yeah, thanks, Dahlia. I think, so one of the things that's so beautiful about this as a solution is it's very easy to understand. And I think one of the failures of, financing student, education through debt has been how complex it's become. You need to hire an accountant almost in order to help you navigate all of these different systems. And we've seen so many failures of some of these systems that have been set up in order to try to provide relief to people. Public service loan forgiveness, I think, is a big one, right? There's so many people who should be eligible for that who've now applied and are getting denied after 10 years of public service and are not getting the cancellation that they're owed. We've seen the failure, I think, with the for-profit colleges and their collapse, and the borrowers who, again, by law, are owed a cancellation of their debts because they were defrauded. And I would argue that the Obama administration's hesitance to give a group discharge, a group cancellation of everyone who attended those schools where they knew the harm occurred, their hesitation to do it that way, and their insistence on an individualized person-by-person application left tens of thousands, hundreds of thousands of borrowers vulnerable to the Trump administration and to Betsy DeVos, who then came in and shut it all down, rewrote the rules, denied people, gave them no relief or partial relief. And so I think complexity in any policy sphere favors the powerful generally and the wealthy, right? Because they can hire the lawyers, they can hire the experts to help them navigate the system. And people that don't have time for that just don't apply for whatever relief is available. And so cancellation is simple. It's easy for people to understand. I think that's part of the reason why we see its popularity. But I think it also will be more effective than some of these other programs because it won't require people, hopefully, depending, I suppose, on how they implement it. But hopefully, I would argue this should not be an application specific thing. And the last thing I'll say on this point is student debt is unique, right? Student debt is not dischargeable in bankruptcy. Dahlia, I don't need to tell you about this, right? But you're the expert here on that.
Technically it is. It's just very hard.
Right. Undue hardship. I'm sorry. Thank you for the correction. But, it's treated more harshly than other kinds of debt and gambling debt. And I think it is also a kind of debt that is held by the government in larger amounts than any other kind of consumer debt. And it's simultaneously the second largest kind of consumer debt out there, second only to mortgages. And so in my view, if the government does not use this very clear authority that they have to provide relief in the middle of a pandemic, with 57% of the people who are COVID unemployed having some kind of student debt, if they don't use that tool, to me, that is an irresponsible, abuse of power in a way, or like failure to use the power that they have. And so I think that to me is what drives the urgency, I think, behind, right? Sort of like to Luke's last point, right? Of course, it's not a perfect solution. It's not a panacea, but it's a tool on the table, and the table's pretty empty right now of other tools. So let's pick up the tool and use it.
Yeah, thank you. I think Luke wanted to follow up on that.
Can I add something to you after Luke?
Oh, yes. Yeah, sorry, I lost. Yeah, there you are. Sorry. Go ahead, Ashley.
No worries. I'll just piggyback on every wonderful thing that Alexis just said, but I think also with IDR, I think, NCLC did a FOIA, right? That over the past 5 years when people should have gotten IDR forgiveness, 19 people have. So you're asking people to rely on a system that literally does not work. And you're also, it's really problematic because you're asking Black and brown people to rely on that system. You're telling Black and brown people, oh, just wait 20 or 25 years and then you can get your life on track. There's something inherently wrong with saying that because you know who is impacted by whether this system works or not. And so when you put up these barriers, you're putting up barriers for, like Alexis said, not just well-resourced people, but also disproportionately white people. And so Black and brown people are the ones who are left out. And so if we want to do something about all of these things, we have to keep that in mind, make it as easy as possible, make it as broad as possible, and give people the relief, not just that the numbers say they need, right? Like, people are asking for relief, right? And they're not asking for IDR. They're asking for cancellation because they see how it's impacting their lives and stopping them from doing other things. And we should want them to have that relief because we know that it's stopping them from doing other things, and that impacts our economy as well.
Yeah, on that point, I just want to take a prerogative as the moderator to say that I think, and to piggyback on what Luke said earlier about, just the larger point of this being potentially a catalyst to rethinking how we think about what education, how the government should fund or encourage higher education, is that, I think this has sort of been a mistake, right? To do it this way, whether it was intentional in the beginning or whether the reason why we kept putting more and more loan programs instead of grant programs, instead of funding Pell, to higher amounts was because potentially because basically more Black and brown people were wanting to get higher education, or whatever, lots of other political reasons. It was a mistake. And now we know this. And so it's sort of like, we're still asking students, just like in the context of students who've been defrauded, to bear the burden of a political mistake, and a burden that is unequal, and that is just, and then if they want to sort of ameliorate that burden, we've given them these IDR, et cetera, other programs and all these hoops to jump through, just like we do for welfare and basically every other program for middle and lower income people, because they need to be deserving, and they need to prove that they're deserving before getting these very basic things. Whereas, the tax code, et cetera, makes it easier for others, whether it's because they have resources or actually because there's less hoops for them to jump through to actually obtain those benefits. Anyway, I want to just open it up. I know I want to open it up to anybody who wanted to jump in here on anything that's been said, and then we'll go from there.
I'd love to make just like a really small point about the sort of regressivity argument, and it's something that's been bothering me since March, among everything else. It's that, the use of this argument would make sense if people, sort of making the regressivity argument either fought just as hard to build out an alternative that met whatever definition of progressivity they've chosen, but that, like, also, by and large, the pause on student debt payments, as part of the CARES Act, and the continued pause and the forbearance is generally agreed to be a sensible idea. I mean, I know that there's some, I'm sure that there are some people out there who don't think it's a good idea, but by and large, I mean, there's a pretty bipartisan consensus that, like, stopping student debt payments was a sort of necessary piece of the recovery, or at least a good piece without, need for much complaint. But if you're making the argument that student debtors are primarily a well-off class of people, you should actually be alarmed at this. You should, you're giving a monthly break to wealthier households, right? But no one's alarmed by this, because we genuinely recognize it to have been a necessary step in the middle of a pandemic, where, as Alexis said, people with some college are, by and large doing very poorly in the economy. 50% of people with some college have lost income since March. And I would submit it's a couple of reasons for that, where there's not this outcry about, the regressive nature of the student debt payment suspension. And it's because it was understood to be a part of a larger economic recovery package, which speaks to the need to, talk about student debt as one of the many things we need to do, even if there is a tool that we can use right now, because people needed relief quickly and in a bunch of different ways. And because for some reason it's not understood to be cancellation or quote unquote forgiveness, right? And that's not a policy question, that's a political question. There seems to be this sort of political or moral, like, reticence to do cancellation or forgiveness when you're doing sort of, or considering doing other things that have the sort of same effect on, the sort of income or wealth distribution, right? So, I don't actually know where that leads us, but it is something that I've just felt the need to get off my chest, because I think, we need to sort of have people remain consistent in this. And if they're bothered by, broad-based debt cancellation, and we can talk about the particulars here, right? We can talk about what's a sort of like reasonable way to go about that, but you're not bothered by, like, quote unquote wealthy student debtors not having to make their monthly payments now, I think it's time to look inward.
Just one quick thing on that, because I don't want people to come away with the student debt suspension is bad, right? The student debt suspension is very good.
Yeah,
I think the lack of criticism is people were so surprised that Trump, of all people, would do this. And I think that creates a bar that Biden has to clear, right? There has been now some $40 billion and counting in student debt relief that has gone to borrowers that came about because of the Trump administration. And so Biden needs to do, at a minimum, that much relief, but really needs to go, I think, a bit higher. And then one other thing I wanted to throw in is there has been cancellation of debt, but it's been cancellation of student loan interest. And so we've already done it. And Trump has already done it via executive action. And I just think that that's important to remember.
Yeah, and any arguments they might have had that this couldn't be done by administrative action, they've ceded there. Luke, I think you wanted to make a point.
Yeah, well, I just want to make two quick points. One is, I think it's also really worth thinking about the baseline here. And this maybe is a different way of stating something that I already said, which is that, like, for me, the question, like often the baseline is the status quo and how are we going to do, and how should student debtors be made better off or worse off, or which student debtors should be better off or worse off than the status quo. But to me, there's like actually a prior moral question, which is like, why is it morally justified to put like people into debt for higher education? And just to sort of frame that in a particular way, like the argument seems to be, you know, education is too good for people. They need to be burdened. Like we need to like, you know, Harrison Bertrand, we need to like put weights on people once they get an education. And like the reason that education is too good is that like the way the employment, like the way that we've designed who gets which jobs and which jobs are paid what, and this is like a relatively recent development, really over the past 40 years, it is, you know, strongly favors people who go to certain types of schools. And like that's not, and that's a different problem. That's not saying like, well, you know, in order to say that it's okay for people to have debt, but and simultaneously it's okay to order who gets which jobs and how we order income through the job system that's highly tied to a very hierarchical higher education system, is to say like, actually it's totally fine that like 40% of the graduating class of elite, first of all, that there are elite colleges at all. Second of all, 40% of them are going to work in finance, which is like a fundamentally extractive project. Like that's fine. That's actually efficient, right? That makes things go well for everyone. We just have to like do this like highly targeted tax, and like that's somehow how student debt works. And I just think that's like wrong. This is wrong on so many levels. And so it's like worth pushing back on the sort of even the moral framework that's being assumed is. And for instance, that applies to like this. Now we're going to see, we're definitely going to see more of this argument. We just saw this argument in the New York Times come out that it's moral hazard to cancel student debt, because then now people are going to take on more debt thinking that it's going to be canceled. And from my perspective, it's like, if people think that's going to be canceled, that is a good thing. Like people should stop thinking about this as a legitimate thing. And the notion that in order for that to be problematic, you have to think that it's actually fundamentally a good thing that this thing continues to keep going. And I just don't think that. So that's like a different moral baseline thing. All right. And the last thing I would say is there's this false choice between student debt cancellation and other forms of relief that also is required to be assumed if you're going to, like, when people say stuff like, you know, student debt cancellation is highly regressive, they usually mean relative to X, Y, or Z other social program. And like, from my perspective, the only reason that works is if you think those two things aren't possible to do at the same time. If you think there's like a limited budget of like good things that can be done, and that requires a theory of like political capital that like everything that you do that's progressive somehow like is a negative sum relationship to other good things. And to me, there's actually the possibility that people don't really consider that actually doing more good things makes it possible to do more good things in the future. And that should be something that we should get used to creating the possibilities for. So canceling student debt might well create a constituency for free college, for canceling medical debt, for, you know, et cetera, et cetera. So
that's actually, I want to just open it up to anybody who wants to talk about how it might do that. I mean, one thing about it is if the Biden administration jumps in and on day one cancels the $10,000 that they spoke about, or some other number, do we think that helps or harms, or sort of begins the conversation of like, well, you know, it's not that that I will take on student debt now thinking it will be canceled in the future. It's why am I taking on student debt now? Why am I being forced to do this, as opposed to not going through that whole thing if it will ultimately be canceled in the future? Why isn't the government actually funding this?
I mean, my very quick response to that is I do think that the way that the Biden campaign at least has contemplated their 10,000 has been as a pandemic response. And so I would encourage people to think about it in that way. I do, however, think it does open up room for these more interesting questions that you raised, Dahlia, right? And I think that conversation is one we have been wanting to have for a long time. And so I think it's sort of a win-win, right? It's like, we're going to do this thing that's a tool on the table that's going to be a pandemic response, and hopefully it'll lead us to ask these bigger questions. That's my real quick response.
Yeah. I have one last question I want to ask, but I don't want to jump into that unless, you know.
I know, I'm sure I'm not the only one with thoughts.
Yes.
I'll just jump in and say, I really appreciate that Luke is taking us to the point of looking at debt-free college going forward. That's the companion measure here. And that is something to which the Biden administration has already made commitments as well. So when we think about debt cancellation, I want to be thinking about about maximum debt cancellation. Let's cancel as much debt as possible. And the Biden on the campaign trail made multiple campaign promises related to different amounts of debt. So $10,000 off the bat, but other campaign promises could be accomplished early on at the same time by increasing the amount of debt that gets canceled through executive action. And the more debt we get off the books, the more problems we solve. We are talking about all of these targeted programs that haven't delivered relief in the past. And if we are moving to a world where students don't have to take on burdensome debt going forward, then when we're looking backwards at folks who've already borrowed, clearing as much debt off of the books as possible frees us up to also get rid of problems in the past, servicing abuses, paying debt collectors way too much money to collect and harass people who just can't afford to pay. We can get rid of those systems altogether if we just clear the books of the debt. So if we want to envision a new world, a different world, that's the world that this administration has, promised that they would kind of herald, and we are here to help them make that happen. Like there may be roadblocks, but we're here to clear them. And I'm really excited about the conversation we're having now.
Yeah. Anybody else want a last word before I ask the last question? Okay, so the last question I think has been asked at every panel, which is given, that we have so many people watching and so many people who will watch this as a recording, and given where we are, we're talking about this sort of great opportunity to sort of change the way that we think about higher education funding, to fix some past mistakes, and to make sure that we don't make them in the future, and to cancel things other than student debt potentially. Give us and everyone watching some homework. What work needs to be done? What work do you hope people will do to move debt cancellation forward? And y'all can look at anybody who wants to start.
I feel like I'm talking too much, so sorry. Just real quick. So we need to hear from you, and members of Congress need to hear from you, and the public needs to hear from you. And so if you are part of any kind of an organization, maybe it's a church group or a religious institution or a community group or a school group or a professional association or a union, whatever kind of group it is, if you all believe that student debt cancellation would be beneficial to your membership, saying that publicly right now in this moment would be very helpful. I think there's this sense about, like I said earlier, who borrowers are. That's wrong. Right? It's this ivory tower sort of belief, and it's just not true. And so maybe it's a letter to the editor, maybe it's calling your member of Congress, maybe it's just talking to your friends. But I think talking about this issue, if it's something that would be beneficial to you or to people you love, right? Because it's not just about like the individual, it's about the network effects. I think that would be really, really, really helpful in this moment.
One thing I'd like to say, it's not homework so much as just maybe a broad.
Oh.
Everybody on this panel and probably everybody.
Oh no.
The language of debt is part here. We sort of brains have sort of been broken by trying to think about this in terms of.
Is it just me or we're having trouble hearing? Maybe if we all turn off our.
But I think I'm hearing.
Okay, yeah. Or if you turn off your video, like maybe so that the.
My connection's bad. I'll just leave it there. Sorry.
Sorry, Luke. I think you wanted to jump in before.
Well, I was just going to say, just to add on to Alexis, I'm going to say it really genuinely very quickly. If this is going to be a positive sum situation where canceling student debt leads to other things, that's going to, the Biden administration is not going to do that itself. The Democratic Party is not going to do that itself. And you'd better believe the Republicans aren't going to do that at all. So, getting involved in doing organizing, there's actually a fairly broad coalition of folks who are doing this. Like being part of that coalition building around student debt cancellation ideally creates a coalition that is also ready to do medical debt cancellation, free Medicare for all or other forms of free care. We don't have to think about this as how policymakers are thinking about this. If you're part of an organization, you can be building a coalition that tries to build the positive sum, positive feedback effect. So that's all.
Anyone else?
I'll just offer that I think what you're all hearing from this panel today and what you've heard from the panels before is that we are a group of folks who are looking for solutions. We are here because we can see the problem and we have clients, we have constituents, we have friends, we have family who unfortunately are telling us heartbreaking stories about what their student debt means and for their lives. So because we can see the problem, we're looking for solutions and we're solution oriented. There are a lot of naysayers. There are a lot of folks who aren't trying to be part of the solution. And I would say, help us drown them out. Help us answer the tough questions. Help us take on the research and make the case for debt cancellation, because we know that it will solve so many problems. And that's what we're after, being the change that's necessary because people have had these unmet needs for relief for so long.
Yeah. Ashley well, Jake already tried. Okay. So I want to give the last word to Mark as co-sponsor of the entire conference. And thank you to Mark and Demos and SBPC. And please take it away.
Wildly
I'm
inflated.
sorry. Thank you to all the panelists. Thank you. It's been great.
I was going to think of it. Dahlia, that wildly inflates my power or responsibility over this event. I actually really want to thank the Student Borrower Protection Center, really the whole team, right? Who worked incredibly hard to put these amazing panels together, cobbled together an incredibly powerful volume at protectborrowers.org that digs into, the weeds of a lot of the stuff discussed today in detail. I have really enjoyed digging into those papers. I have learned a lot of stuff that I did not know before, and actually plan on cozying up over the holidays to it again. So that's my plug for the volume. Logistically, I'm told that the recording for this event will be available next week for those who maybe missed a panel or were doing other stuff for different parts of the day. I know it's been a long but really rewarding day, so the recording will be available next week. Of course, thank you to Senator Elizabeth Warren for kicking this off today in a way that only she can. And just sort of like to conclude, I want to go back to something that Seth actually said as we started the day, and I wrote it down. He called out the unconscionable reticence to provide relief by the people who broke the system, and I found myself applauding that. How could you have sort of brought us to this moment and then balk at what is, I think, a very sensible idea, which is provide some broad-based debt cancellation and make sure that going forward that people have the tools to cancel a debt that they never should have had to take on, were suckered into, or what have you. But as a ray of hope, for those of us who have been in this discussion and in this fight for the last several years, this genuinely feels like a different moment to me. And I think that's a number of reasons, right? There's a different moment because of the genuine crisis in our economy. It's a different moment because of the political leadership that we've seen from Senators Warren and Schumer and Sanders and Reps Presley and Omar and Pocan and Jayapal and Clyburn and more, and President-elect Biden, whose campaign promise of broad-based debt cancellation marks a pretty seismic shift and an opportunity, as we've been talking about in this last panel. It's a different moment because of the tireless work of many of the panelists today, doing creative legal work and policy research, trying to untie some really tricky policy knots, working with borrowers, organizing, working with advocates and activists at the national, state, local, student, borrower, institutional level. you know, and that matters, right? That's what brings us to this moment, I think, as Luke was saying before. And it's a different moment because of the millions of people who have stood up to protect and center Black and Brown lives and build Black and Brown power over the past year. This past year, we've seen the leadership of a racial justice movement, frankly, that questions a lot of the failed assumptions behind our economy and our safety net. It asks us to sort of build a future that isn't based on exploitation or debt, where success isn't precarious, where predatory actors aren't lurking behind every corner, but actually where we can dream bigger, we can expand public goods, we can make this system, frankly, work for this generation in a way that it did work for previous generations of Americans who looked a little bit different, but who could rely on and count on robustly funded higher education, you know, a Pell Grant that met the cost of college, and where debt was not, you know, the central way to finance school. And I would submit that if in the year of our Lord 2020, if we're truly at a moment of reckoning about the way racial injustice permeates our economy, I don't think you can stand idly by on student debt. So what I'm taking away from today is that we need to think big and specific. We need to push for broad cancellation and give relief. Yesterday, I think someone said, you know, day minus 100 before to those who were defrauded half a decade ago, whose only crime was getting an education. I don't think we can reiterate that enough. And whose government, frankly, said for decades, trust us. This is a program in a school with our seal of approval. This is good debt. Go for it. You know, you'll be fine. And as this conversation continues, I think, you know, I want to ask that we remember that these things aren't mutually exclusive, as I was talking about before. This is a problem that's big. It's $1.7 trillion big. It requires a whole suite of solutions. And these things, whether it's BD, PSLF, IDR, what have you, can work and should work in tandem with broad-based debt cancellation. So with that, I think I have the last word. Thank you, everyone, for sticking around the past few hours. Thank you again to the Student Borrower Protection Center. Thank you to the leadership of Demos, especially our president, Sabeel Rahman. This is an exciting time, but amid the excitement and the wonking out and the push forward and the many acronyms we've spouted out today, I hope everyone has a really restful weekend, a safe holiday season and New Year, and take care of each other.